So, chapter 6, estates and interests. In this chapter, we're going to talk about the characteristics of estates and land. We're going to describe the characteristics of encumbrances, like liens, easements, and encroachments. First of all, what is an estate in land? So, on the bottom of page 103, an estate in land describes the amount and kind of interest that a person has in real property. I know my definition is a little bit different from what you see in the book because this chapter specifically talks about the category of ownership estates. So its definition says it is the amount and kind of ownership interest. But we also have less than freehold, less than ownership, which would be a leasehold estate. So to be true to the definition of an estate and land, it describes the amount and kind of interest that a person has in real property. There's two categories of estates and land. We have freehold estates, which denote ownership. This is the ownership category of estates and land. And there's three types that we will go over in this chapter that we call freehold estates. So anytime you hear freehold estates, we're talking about ownership. You're free to hold that property forever or a lifetime. If it's not ownership, it's a leasehold estate, which is less than freehold. You're not free to hold it forever or a lifetime. We're going to go over those four types of leasehold estates later in chapter 12, but we'll skim over them in this one, just giving you the names of them. So the amount and kind of, this is at the bottom of page 103. I want you to cross out the word ownership because this will be a more true definition. The amount and kind of interest that a person has in real property is an estate and land. This particular chapter, like I said, is talking specifically about ownership. That's why they got that word there. So we have the freehold estates, which I want you to write next to that is the ownership category. There's three types, which we'll go over. And then there is the leasehold estates, which is less than freehold. And there are four types, which we'll go over in chapter 12 later on page 226 in chapter 12. Let me know when you have those notes and highlights. Thank you.
Yeah.
Anybody still writing? I'll take that as a no. Okay. We have three types of freehold estates that we're going to go over in this chapter. They are fee simple, fee determinable, and a life estate. These are the three types of freehold estates that we will be going over in this chapter. So at the top of page 104, let's write the number 3 instead of in front of freehold estates. And then we'll just highlight the three types of freehold estates: fee simple, fee determinable, and a life estate. And then just beneath that, they talk about leasehold estates before we get into anything. So we're going to highlight leasehold estates involve tenants for a period of time. Leaseholds are considered to be personal property and not real property because you don't own the real estate. And they are considered an intangible or an incorporeal, if you recall that word, asset. So what is a leasehold? Well, leasehold estates involve tenants, and a lease signifies the tenant's rights to occupy an owner's property for a limited period of time as defined in their lease. Leases involve tenants, who is the lessee, and the owner, who is the lessor, because they're the one that's giving the lease, and the tenant's called the lessee because they're the one that's getting the lease. Words that end in OR, words that end in EE, if you recall. So a lease is a personal property that's an intangible or incorporeal asset. It's not considered real property ownership. A lease describes a tenant's rights to occupy someone else's property for a limited period of time as defined in their lease. It says when the leasehold starts, when it ends, right? As well as the terms and the length of time, what's being leased, any limitations on the estate, when the rent is due, yada, yada, yada. You get it? So there are 4 types of leasehold estates that we will discuss later in chapter 12. They are an estate for years, a periodic estate, a tenancy at will, and a tenancy at sufferance. A tenancy or estate at will and a tenancy at sufferance. Those are the 4 types of leasehold estates that we will go over in chapter 12. So let me back up the slide just a little bit. Yeah, let me back it up.
One question, Victor.
I'm sorry?
One quick question.
Yeah.
It's not related to this freehold thing. It's
Mhm.
more lease type. So the residential apartments, what we get the lease on, right? It's always 11 months. Why it's not a full year?
It should be 12 months.
Normally it renews after 11 months or something.
Oh, yeah, because they need to know if you're going to be getting out or if you're going to be renewing. So they'll send you the lease with before it expires. So, excuse me. So you can let the landlord know if you're going to be renewing that lease or not. So they know
Okay.
if they should be expecting you to be leaving and that they should start advertising to get a new tenant to replace you once you get out.
Okay.
Okay. So if we back it up to this chapter, to this slide once again, an estate and land describes the amount and kind of interest that a person has in real property. We got the freehold estate, and there's 3 types of them, and we got those leasehold estates, and there's 4 types. So the 3 types of freehold estates are fee simple, fee determinable, and the life estate. And the 4 types of leasehold estates are estate for years, periodic, at will, and tenancy at sufferance. You need to know this for exams. So study that term. What is a freehold estate? It's the category of estate and land that talks about ownership. And a leasehold estate is less than freehold. It's the category of estates and land that just talk about the non-ownership interests. So let's get into the nitty-gritty of the freehold estates. So on this slide, just do all the highlights and all the underlines, and then I got other slides where we'll go over everything in detail. Okay, so write these notes here, write these notes, do all the highlights, underlines, and all that, and let me know when you are done. This is all on page 104. And I'll just pause this recording while we get all the highlights and notes down. Okay, so everybody's done? All right. So the 3 freehold estates, to recap, we have fee simple. It goes by 3 different names. It's also known as fee simple, or fee simple absolute. That all means the same thing. It's the highest form of ownership that's recognized by law. It's the most complete form of ownership. It's ownership forever. You own that property even after you die. You could decide who gets it. So it's ownership forever without any restrictions on that ownership. Then we have fee determinable. Also goes by the name defeasible fee and conditional fee. So this one goes by 3 names too. Fee determinable, defeasible fee, or conditional fee. It describes the same thing. It is that ownership forever, but that ownership is based on a restriction. And that restriction is called a restrictive covenant. A covenant, once again, is a legal promise. So that legal promise that you agreed to when you bought that property, you agreed to abide by it, as long as you don't, whatever that restriction is, as long as you don't violate that restriction, you remain the owner of the property. But if you do violate that restriction that's placed on the ownership, then the person who sold it to you or their heirs could come after you to get the property back because you violated the terms of your sale. And that passes on from one owner to the next. So even if you were to sell that property to someone else, they need to abide by those restrictions as well. Because what are you buying when you buy a property from someone? You're buying the property, but also all the rights that they have. And sometimes those rights may have already had restrictions applied to them. So you could only inherit the rights that the person had when they sold you the property. They don't create any new rights for you. So if the restriction is violated, the ownership would revert back to the person who placed the restriction in the deed. And that is called the possibility of reverter. Because if you violate the restriction, it is possible that that ownership will revert back to the previous owner or to a remainder man. Now, what is a remainder man? Another word to know to add to your definition list. It's a third party named in a document, which we'll refer to as an instrument. And an instrument is another word for document. It's a third party named in an instrument to be a beneficiary. So it doesn't necessarily have to be your heirs or come back to you. You could say, hey, if that restriction is violated, it'll go to the neighbor, you know. The restrictive condition runs with the land. So it passes from one owner to the next, and it can only be removed by the person who added the restriction to the deed, their heirs, or by a court. Although the court's not likely to remove it, so don't count on buying it and being able to get a judge to change it. They like to respect people's property rights, or they should. Now, a life estate is just what it sounds like. It's ownership as long as you're alive. So a life estate is ownership based on the life of the person the estate is measured against. They can't leave it by will, and they have all the rights of ownership to sell, lease, mortgage, or give away the property. But they can't destroy that estate's value. And upon their death, the ownership would revert back to the person who gave the life estate, or to a remainder man or their heirs. So, yes, life estates are usually given. An example of a popular, famous life estate would be Hugh Hefner's Playboy Mansion here. Let me open this up. You guys remember Hugh Hefner, Playboy magazine? Wasn't that long ago. You guys know what that is?
Yes.
So Hugh Hefner, the ultimate Playboy, he had this mansion, this Playboy mansion there in Beverly Hills for the majority of his life, and when he sold, he actually sold. He's dead now, but he sold that Playboy mansion before he died. But he put a stipulation in the sale that whoever bought the house, look at this sign. What does it say? Read it carefully. For sale with owner, not by owner. So whoever bought the property was getting him along with it. they had to agree to give him back a life estate so that he could live there for the rest of his life. Now, at the time, he was already up there in age. He was 89 years old. You know, he was selling that 29-room, 6-bedroom Beverly Hills mansion, which was in decrepit condition from all the partying that went on in there for ages and ages. All that partying that was going on in that Playboy mansion. His little lapdogs walking around and peeing and crapping wherever they wanted. You know, people spilling drinks and whatever else you could imagine going on in this house for all those years. He never updated it. So it was just basically falling apart. But he sold that Playboy mansion. He was looking to sell it anyway, upwards of $200 million. I think he sold it for maybe about 90 or 100 million. Now, why would he put such a restriction in there that I'm going to sell the property, but only if you give me it back and let me live here for the rest of my life? Well, because he loved the house and he didn't want to move. So why did he sell it? Anybody know why Hugh Hefner sold the Playboy mansion? Take a wild guess.
He needed money.
He needed money. What? The Playboy magazine? What, he was running out of money? Well, he's 89 years old. He's been living a partying lifestyle with 24/7 chefs on duty to cook up a meal for anybody, for him or any of his guests that were there. He had ex-wives, yet he hooked up with a yacht, and the yachts don't run themselves, expensive, those large boats are expensive. They need a whole crew to run. So it's not cheap to have all those ex-wives that you were with when you were super rich here. That you're giving away a lot of money there. You're maintaining this partying lifestyle all the time, and magazine sales are going down with the invention of the internet. Sure, he had the Playboy website and Playboy TV and all, but he sold off some of these assets too. He put his daughter in management of Playboy magazine for a while. He retired already a while ago. He was just the figurehead there. So his daughter was managing it. And then his daughter, after 10 years or so of managing it, she decided there was something else she wanted to do. And so he put his son in charge of Playboy magazine. His son's super, super liberal, went to those colleges in California there. He decided that he's going to have some fun with Playboy magazine. Not the type of fun that a typical boy may have that is of Hugh Hefner, you would imagine. So for his first edition of the magazine, he decided that he was going to do something interesting and fun, and the readers would love it. Now, what do any readers buy Playboy magazine for? It's not the articles, even though their articles are said to be really good. It wasn't that hard-hitting reporting going on in the magazine. It was to see nude women, right? So he decided that he was going to have the first transgender Playmate centerfold. So imagine the shock and dismay when their avid subscribers and readers seen that. So a lot of subscriptions were dropped. They lost even more business. Not that it was in good shape to begin with. So it was already going downhill. So Hugh needed money. So he sold the mansion with the agreement that he gets a life estate. Yeah, he ended up selling it. Oh, they were estimating 80 to 90 million. Yeah, I think he sold it for about 100 million. And he sold it to his next door neighbor. Some young guy, I think he was in his late 30s, early 40s, had that kind of scratch. And he bought the neighboring Playboy mansion. Yeah. Imagine that. Another young guy that's got more money than he knows what to do with. But he agreed to Hugh Hefner's terms, and then Hugh Hefner only lived for 1 year after he sold the Playboy Mansion. So the guy didn't have to wait very long to get it back, right? There's some interesting stuff with that Playboy Mansion too. Let me see. What's that? Playboy Mansion. If you guys take a look, this guy bought the Playboy Mansion, and then he started doing some renovation. Now he agreed also in those terms not to tear it down. So here was the Playboy Mansion when he bought it, and then he started doing this to it, renovating it. The whole thing needed a work over. He gutted everything, got rid of that driveway. Look at that. So everything is in the process of getting changed around a bit there. And from my understanding, he's still working on it. To this day, he still hasn't finished and completed this renovation of the Playboy grounds and mansion with the other guest houses and the grotto and the pools and all that stuff. Grotto is back there, pool over here, front lawn, tennis courts. Everything needed a makeover. All right, so there's a real life example of a life estate and when it would be used in those types of situations. Now, there's a little bit of a spin to the life estate as well. There's something called the life estate pour autre vie. What does pour autre vie mean? Now, this is not P-O-R, it's P-U-R, so it is Latin. It is not French. If it was French, it would be P-O-R, pour autre vie. Still pronounced the same, pour autre vie. It means for the life of another, or based on another's life. So it's a life estate that's not based on the person's life who it is given to, but based on a third party's life. You could just imagine a lot of situations of where this could possibly be used. So that's what a life estate pour autre vie is. You need to know that term pour autre vie for exams. You need to know what it means. It will be on exams. It's for the life of another or based on someone else's life. You guys want to snap a screenshot of this slide, which lays out all of that stuff that's on a couple of pages there, that's both on page 104 and 105 with a little bit better definition there. Be my guest. 3, 2, 1. Anybody need more time? Okay. So fee simple, just a recap, is the highest form of ownership recognized by law. It is unrestricted ownership forever. You could even decide who gets the property after you die. It also goes by the terms fee simple, and fee simple absolutely. It's absolute ownership. And then we have the fee determinable. It is ownership forever, but it is based on some sort of restriction. In New Jersey, an estate that can terminate on the occurrence or non-occurrence of a specified event. This is called a restrictive covenant. It's also known as defeasible and conditional fee estate. Fee determinable, defeasible fee, and conditional fee estate. It is ownership forever based on a restriction. As long as that restriction is not violated, there's no issue. But if it is violated, that ownership would revert back to the person who placed the restriction in the deed, or a remainder mean. So the restrictive covenant runs with the land. That means that it passes on from one owner to the next. It cannot be removed except by the person who put the restriction in the deed, their heirs, or a judge if it later on turns out to be an illegal restriction. Then we have the life estate. It's The life, it's based on the life of a specific person in which their life is based on. The ownership would revert back to the person who placed or granted the life estate to their heirs or a remainder man. The life estate can be tied to a third party. That would be a life estate porotravie. And the holder of a life estate has true ownership of real property with all the rights and benefits, but only for their lifetime. A life interest may be sold, leased, mortgaged, or given away, but it always will end on the death of the person against whose life it is measured. So say that I sell my property to you and you give me back a life estate. I could move out. I don't need to stay there. I can move out and I can lease the property and collect the income from that. The thing is, I cannot destroy the value of the estate. I got to make sure the taxes are being paid, so I can't risk it being foreclosed on or anything like that. I got to maintain that estate. But as soon as I die, I lose the property. And if I was renting it to somebody, they got to get out, as well as if I were to sell it to somebody. I mean, how do you even value a life estate to sell it or buy it? Who would buy a life estate that's based on my life? I could get hit by a bus tomorrow and die, and then they lost it, right? So you probably wouldn't pay a whole lot for it. So that life estate is ownership based on a life. And it does have that reversionary interest. And then on page 105 is where you could highlight a life estate porotravie for another's life on page 105. You already have this stuff highlighted, but this you may not. So page 105, a life estate porotravie. And the holder of a life estate does have true ownership of that property. The tenant cannot, however, waste the property. That is, the tenant cannot perform any acts that would permanently harm the land or the property or destroy its value. A life tenant is entitled to all the income and profits arising from the property and is responsible for paying taxes on it. A life interest may be sold, leased, mortgaged, or given away, but it always ends on the death of the person against whose life the estate is measured.
Question on that life estate.
Yep.
Since you got the property and you have that particular arrangement, right? Is the
Yep.
person living in there allowed to make any kind of modifications in the property?
Well, it depends on their landlord has to give them permission, right? You could do improvements on you could do improvements to a property because you have ownership and you have all the ownership rights. You just can't waste or destroy the value. You could improve it.
Okay.
Now, this is the way reversionary interest can work, the two ways. The grantor gives the title to a life tenant, and when they die, the title returns to the grantor. Or the grantor gives the title to a life tenant, and then upon their death, it goes to a remainder man. Now, the grantor could still be alive. A remainder man is not somebody in a will. It's just once this person dies, who gets it? It could come back to the person who gave you the life estate, or it could go to another party, a third party, called a remainder man. So let's get to this dower and courtesy one now, officially in the book. We've heard about it a couple times. Here's the first time where we're actually seeing it, because you saw it on my slides, but not yet from the book. Now you're getting it in the book, and we're going to have a place for you to highlight it in a moment, but let's first see it on the slide, and then I'll show you the screenshots and what to highlight. So dower and courtesy are ancient rights that a spouse has in their spouse's property. That one spouse has in their spouse's property. Dower is the wife's interest in her husband's estate upon his death. And dower begins with a doe, and a doe is a deer, female deer. So that's the way I remember that. That's the female, the wife's right. And courtesy, because men are courteous to women, is the man's right in the wife's estate, the husband's right. And New Jersey abolished the creation of any new dower or courtesy rights as of May 28, 1980. And now, instead, they give both the husband and wife the right of joint possession of the property that is their main marital residence. Now, if you're going to bring up at all gay marriage or anything like that, well, that did not exist in New Jersey at the time. So, look, Governor Christie didn't sign gay marriage into law in New Jersey until he was governor. That was just a couple of years back. Yes, a Republican governor actually signed gay marriage into law in New Jersey. So, dower and courtesy are those rights of those spouses. All right, so here's what to highlight.
Got it.
Yeah.
All right, everybody good? So why do we need to know about dower and courtesy rights? Well, who needs to sign listing agreements? Who needs to sign the sales contracts? If you got a married couple, do they both need to sign? What if only one is listed as the owner? Well, it depends when were they married. They were married before May 28, 1980, and only one is listed as the owner. They both need to sign because the spouse has an interest in that property, even if it's not the main marital residence. If it's the main marital residence, it doesn't matter when you were married, both spouses need to sign. But if it's not the main marital residence and only one spouse is listed as the owner, only that one spouse needs to sign. But any buyer or buyer's attorney is going to look out for their clients, and they're going to want the other spouse who's not listed as the owner to sign what's called a quitclaim deed to give up any interest or rights or claims, possible claims that may arise from them of interest in the property at a later date. Oh, what's going on? So an encumbrance is a burden on the property, claim, lien, charge, or liability attached to and binding on real property, limiting its value or title. That's what encumbrance is. Should usually stop right here. And at this point, I usually ask people, hey, what's an encumbrance? Do you know what an encumbrance is? If you're encumbered by my weight because I jump on your back, you know, an encumbrance is anything that holds you down, holds you back, right? If I jump on your back, you're encumbered by my weight, right? Can you move around? If I jump on your back and I'm holding on, can you move around still?
Yes.
Yeah, but limited.
Yeah, but it may be a lot harder to, right? Especially depending on my weight, right? Yeah, you can move around. It's just going to be a lot harder to. Okay. Now that you have that image and that thought train in your head, let's look at encumbrances, because the same situation applies to encumbrances with real estate. We just need to know what those encumbrances are. And they are any claim, lien, charge, or liability attached to and binding on real property, limiting its value or title. Those are encumbrances. Now, can you still sell property, move around, if it is encumbered by something? Yes. It's just going to be harder to. So a lien is a financial claim on a property. We have mortgage liens, tax liens, lawsuit judgments, mechanics liens. That's a contractor's lien when you didn't pay them for doing work on your house. You have physical or usage encumbrances. Those are deed restrictions, easements, licenses, and encroachments. The license is permission. If I gave my neighbor permission to come on my property for some reason, that's a license. It could be verbal. An encroachment is any manufactured addition that goes over the property line. That would be encroachment. That's anything that anything that illegally crosses over the property line. And then we have here's a little brain teaser for you. All liens are encumbrances, but not all encumbrances are liens. Well, that's right. Because if we were to translate what a lien is in our head and what an encumbrance is in our head, let's think about it. What is an encumbrance? It's a burden on the property. So all liens, what's a lien? It's a financial claim. So all financial claims on properties are burdens on the property. Makes sense. But not all burdens on property are financial in nature. That's true. Because we also have physical and usage encumbrances, right? See, this is the way you should read questions on an exam. Because you're learning all this new terminology and stuff, and you're going to have these new terms that are used in the question. And so, although you may understand them, it makes it a little foggy unless you really, really studied these terms and definitions and got them down. So it's a good idea to translate the questions in your head to a way that's easier for you to understand and remember. Then it makes it real easy to figure out the problem. There we go. I don't know why that was there. These things are already highlighted. So let me actually get to this slide. Talks about encumbrances. Gotta delete all these highlights. There we go. So do the highlights there. An encumbrance is a claim, lien, charge, liability attached to and binding on real property. Liens are financial claims against the property. Then there's physical and usage encumbrances, which include restrictions that may have been added into the deed on how you could use your property. Yeah, that could affect its value and saleability, make it harder to sell, right? If there's a restriction on how you could use a property. Selling you a gas station, but you can't use it as a gas station. Right? Okay, well, that may be fine for somebody who wants to turn it into an office or as a auto shop and they have no intent on pumping gas. Easements, encroachments, and licenses. And then here's that little brain teaser for you again.
Question. The deed restriction, can they be called predeterminable?
What's that?
The physical and usage in incumbents,
Uh-huh.
the deed restriction, right?
Yeah.
Can they be used as a predeterminable?
Well, hold on a second. A restriction placed in the deed is called a restrictive covenant. What kind of estate and land is based on a restriction? What did you just say? The feasible fee, also known as a conditional fee estates based on a condition, fee determinable, feasible or conditional fee. That's the type of estate. So you're on the right track there. I just want to correct the terminology of it a little bit. Okay, that's the type of estate and land that's based on a restriction.
So what is a deed restriction then in that case here?
well, I just gave one example. I sell you a gas station that I own. I'm the owner of a gas station. I sell you the gas station, but I put a restriction in the deed that it can't be used as a gas station anymore.
Got it. Got it.
Okay. Could that affect who you're selling it to? A lot of buyers may not want it because they were intending on having a gas station. But then others may not care because they just like the location and the land. So they're going to put up an office there for something, maybe put up a real estate office or something, something of that nature. So it doesn't matter to them. Or maybe somebody's just going to buy it and use the building as a garage, an auto shop, auto repair shop, and with no intent to pump gas. But if they ever do start pumping gas, well, then they're violated the terms of the sale, and there's that possibility of reverter where the ownership would revert back to the person who put that restriction in the deed. All right, now liens. Let's do our highlights here. Page 106. A lien is that financial claim. See, this is all that stuff that was on that one slide, but now we're just getting to the highlights, which are peppered all over the book. I had everything nice and neat. So a lien is the financial claim against property that provides security for debt or obligation of the property owner. Liens are classified either as voluntary or involuntary, or general or specific. So what is a voluntary lien? It's one that's created by the property owner. You went out of your way to get it, like the mortgage loan to buy a house. Involuntary lien is one the property owner didn't want. It's one that's imposed on the owner without their consent, like property taxes. Who the hell wants to pay those? Well, you got no choice. So this is one that was imposed without the owner's consent. So therefore it is involuntary, but you still got to pay them. And then liens can be general or specific. General lien affects all the property that somebody owns. And it's not just real estate. It affects even your personal property. Specific liens are placed against one parcel of real estate only. Did you guys get that?
Got it.
Got it.
Got it.
So once again, voluntary lien created by the owner, involuntary lien created without the owner's consent. General liens affect all the property you own, real and personal, whereas a specific lien only affects one parcel of real estate. They give you some examples here of specific liens versus general liens. Ad valorem tax is your property tax that all property owners pay. A utility lien, if you didn't pay your gas bill or water bill or sewer charge, okay, or your mortgage lien. Look, if you don't pay your mortgage lien, if you don't pay your taxes, if you don't pay utilities, you can get foreclosed on, right? Now, foreclosure is the legal process where a lien holder can force the sale of the property to get their money back that they're owed. That's basically, in a nutshell, what foreclosure is. And New Jersey is a judicial foreclosure state, meaning it has to go through the court system. So if one property gets foreclosed on because you have a lien on it, if you have a lien on one property where that property could get foreclosed on to pay back the lien, if you didn't pay your taxes, for example, on one property, or if you didn't pay your mortgage lien on one property, could that affect another property that you own, another house?
No.
No, it only affects that one property. Now, types of liens are a different matter. You know, you have the general liens and specific liens. That's a little bit different. In a general lien, you could have judgments, estate and inheritance tax, deceased person's debts, corporate franchise tax, IRS, you didn't pay your federal income tax, child support, You know, these could become general liens against all the property you own, not just real estate. So,
But when the lien is against a property, right?
uh-huh.
In the general lien, how can you attach the other properties or say that there is a lien? Where does it show up?
Record the document in the public record. That's why we
But-
have the Recording Act, which we actually go over, I think, in chapter 21. There's the Recording Act that allows us to record documents in the public record. Anybody who has an interest in a property can record documents in the public record, putting the world on notice that we have an interest in that property. That's the purpose of the Recording Act.
Okay,
Now,
that
it should be legitimate, but nobody's out there confirming that it is. But if you find out there's a lien on your property that doesn't belong there, well, take legal action to get that lien removed against the person who put it there if you have a dispute about that. But a person has a right to put it out there. Now, if you got a person that's just frivolously putting liens on properties, that could be an issue.
See, but again, even in this case, you're putting a lien against a property.
Yeah.
But when you talk about the general lien, right?
Uh-huh.
It goes against the personal property as well as, let's say, car.
Against
But how
all
do you-
property they own. Yep. Mhm. Let's say I sue
But-
you. Let's say I sue
Okay.
you and I win, and the judge says, okay, he owes you $10,000 now. Okay,
Mhm.
so I got a judgment from a court. What is a judgment? It's a piece of paper that says you owe me money. That's all it is.
Yeah.
Now I could take that piece of paper. I do research. I find out you own a house. I could go down to the county hall of records where that ownership records are being held, and I could attach my court order and turn it into a lien against your property. A lien is a financial claim on that property. So I'm saying that owner owes me this money and I'm attaching it to the property. So I'm basically saying this property owes me money. And until I get it paid back, I have an interest in this property. So now any potential buyer that steps forward to try to buy that property, they're probably, and they should, do a title search, which would uncover such liens. And now, would you want to buy a property that has a lien on it, where it says that somebody has a financial claim on it? Or would you want to make sure that that financial claim got cleared up before you went through with the purchase?
Got it.
All right? You'd want to make sure that that gets cleared up, right?
Yes.
All right, so effects of liens on the title. Well, encumbrances, liens, and other kind, they run with the land. So, could you buy a property that has liens on it without clearing them up?
Yes.
Sure you can. Because you may not have done any title searches or anything, or maybe you did the title search and you found out that there was a lien on the property, but you decided to go through with the purchase anyway, for whatever reason. So yeah, you can purchase it. So that lien will pass on from one owner to the next, because liens attached to the property, not to the property owner. And that's the very next sentence here. Liens attached to property, not the property owner. That's why it's always in the buyer's interest to do a title search to find out if there are any unpaid outstanding liens on a property before going through with their purchase. So once again, encumbrance, liens and otherwise run with the land. Liens attached to properties, not the property owner. Real estate taxes have first claim against the proceeds of such a sale that may have forced repayment of a lien, like foreclosure. We're talking about foreclosure sales. Two things certain in life: death and taxes. You're all gonna die and you all have to pay taxes. Hell, you gotta pay your taxes even after you die. The state will come get it out of your estate before it's distributed to anybody. That's why they require any estate to be probated. So liens, voluntary liens, are something you wanted, like a mortgage loan or a home equity line of credit where you could use your home as a piggy bank to drain out any equity that you built up. Involuntary liens would be real estate taxes. There's specific liens on the property. You have unpaid federal income taxes. That's the IRS general lien against all property that you own. Now, they could come after your car, your bank account. They could come after you, stick you in jail every day you're in jail. That accounts for so many dollars. A lawsuit judgment, that becomes a general lien. So do unpaid child support tax, unpaid child support. That becomes a lien on the property as well. All right, so when you did pay off a lien, do they remove that lien from the public records? No, they don't. Once something is added to the public records, it's there forever. The only thing they do is they just add another document to the public records showing that the lien had been satisfied. It was paid back. This is known as a satisfaction of lien. So a document recorded by the lender in the public records shows that the lien had been satisfied or paid off. That's a satisfaction of lien. So once the lien is paid off, they should add another document to the public records that says the lien was paid off and there's no more outstanding lien on this property. Any liens that are found on the property create what's known as a cloud on the title. You guys remember those Bugs Bunny, or those old cartoon those old cartoons where you'd have a thunderstorm cloud just hovering over one house in the cartoons? You guys remember that? You guys ever see such a thing?
Yeah.
Yeah.
Okay, so just have that picture in your head, that image in your head, that a cloud on the title is like a thunderstorm cloud hovering over your house. Would you want to buy a house in a neighborhood that always had a thunderstorm cloud just hovering over that house?
No.
Yeah, who would want that? So you would want to make sure that the owner clears that cloud up and let the sun shine in before you go and buy that house. So the cloud on the title, that kind of imagery gives you the idea that a cloud on title means ownership. There's a cloud hovering over the ownership, meaning that there's a problem with the ownership. I mean, what kind of house has a thunderstorm cloud always hovering over it? Kind of tells me there's some kind of problem over there. I'd like to make sure that problem is cleared up before I ever try to buy that house, right? So that's that kind of imagery, that little explanation of that cartoon cloud over the house is just to show you that it's a bad thing, it's a negative thing. You don't want to buy a house that has clouds hovering over it, unless the juice is worth the squeeze. It's worth it for you in some way. How could that be worth it? Well, the juice is worth the squeeze. There's a lot of reasons why sometimes you may be willing to buy a house that has liens or encumbrances on it, or maybe it's look, a house is worth, let's say we have a real estate, it's worth $300,000. You make an offer of $300,000. The house will appraise for it, but there's also a $50,000 lien on the property that the seller doesn't want to clear up. Would you want to buy this house now for $300,000, knowing that there's a lien of $50,000 attached to it that you would have to pay off, or that could be the payment to pay it back could be enforced by foreclosing on that house that you just bought? Would you want to buy that?
Depends if the juice is worth the squeeze.
And what would make the juice worth the squeeze for you?
Well, it depends on my purposes for the house.
Well, it could depend on your purposes for the house. Maybe you own the properties all around that one property and you needed that property for some particular reason, and that would be worth it for you in the long run. So you're willing to take that extra $50,000 debt on because it'll make up for it in the long run. You're going to make out like a bandit, right? Or maybe you have knowledge about that property that other people don't. Something is going to be going on in a neighborhood that's going to be bringing up the values tremendously. Or maybe you happen to know something about some precious metals being on that property, or precious, what do you call it, minerals. Maybe there's oil and gas there. Maybe there's gold or diamonds or some other precious minerals that are on that property that the owner is currently unaware of. Then you'll be like, yeah, I'll buy that property with that. Or maybe you could even negotiate down on the price a little bit. And if you negotiate down on the price a little bit, maybe 50,000, you'll take the property along with the encumbrance, and then you'll take on the responsibility of paying the encumbrance. That lien. All right, so let's look at different types of involuntary liens. So we'll start off with the process of escheat. How does that work? Well, a person dies intestate with no heirs. And through the process of escheat, the state takes the property. Eminent domain through condemnation suits and payment of just compensation. If land is needed for a public use, eminent domain powers are enforced, and the property is taken by a public or governmental or quasi-governmental agency. Or for non-payment of, foreclosure is in New Jersey anyway. We have some states foreclosures judicial process, or some states it's non-judicial. New Jersey, it's judicial. It has to go through the court system. So non-payment of a debt secured by real estate as the collateral for that debt. Through the process of foreclosure, the sheriff would sell that property to the highest bidder at auction. Adverse possession is when open, notorious, continuous, hostile, and adverse use of another person's property for a period of time as prescribed by state law has been used. Through the process of adverse possession, an adverse possessor can claim ownership. We're going to go over that one a little bit more, I think, even in the next chapter, chapter 7. So, what establishes the priority of liens? Which liens get paid back first in the grand scheme of things? If there's a bunch of liens on the property, what lien gets paid back first? Debt
Well,
and
taxes always get,
Yeah, taxes always jump to the head of the line. They will even jump ahead of a first mortgage loan that's outstanding. Two things are certain in life: death and taxes. They always jump to the head of the line, right? So the priority of liens is determines the order in which they're repaid. Now, in normal circumstances, if your taxes are all paid up, in the event of foreclosure, the priority of which liens get paid back first is established by the date of recording of that lien in the public records, with the exception of two liens only: taxes, because taxes always jump to the head of the line, or a mechanic's lien, which is a contractor who had not been paid for work that they performed. These ones are retroactively backdated to the date that the materials were delivered or the work was performed or started, whichever happened first. So you could have several liens on a property, and then a contractor goes and records a mechanic's lien, and it jumps ahead of your lien. How could they do that? Well, when did they do the work? When were the materials delivered? Did that happen before you got awarded your lien or you recorded your lien? If so, they could jump ahead of you. So let's highlight that priority of liens and how they're established.
Got it.
So when you do a title search, the person who searches the public records, that abstractor, they basically put down the address of the property on a piece of paper, and then they make a list of all the documents they could find in the public records, and they put them in chronological order according to the dates that they were recorded in the public records. Liens and other encumbrances run with the land. Once again, that means they pass on to the next owner, and liens attached to the property, not to the property owner. That priority of liens is establishes the order in which the liens or debts are repaid. Tax liens take priority over all other previously recorded liens. Otherwise, they're repaid according to the date they're recorded in the public record, with the exception of a mechanic's lien, which its priority is retroactively backdated to the date the work began or the materials were delivered, whichever happened first. And then it goes according to mortgage liens, judgments, and other kinds of liens are according to whatever date they recorded them in the public record. I just have you do these highlights here, and then we're going to move to the next one because we just went over these.
I'm done.
Got it.
Now, lis pendens, this is new. Let's highlight that. A lis pendens, this is page 109, is a public notice of possible future legal action against the property. What kind of legal action is taken against a property? Foreclosure. So if somebody falls behind in their mortgage payments by more than a month, the lender usually will give somebody, they'll have to be behind by more than a month before the lender even realizes you're behind on something. You got to be behind a little bit. The lender will generally give you some time to try to pay it back, get caught up. So in the meantime, let's say if you're behind on your mortgage payments by a month or two, the lender will record a they'll record a document in the public records that says you owe them money and possible future legal action is pending on this property. That legal action being foreclosure. So now if anybody's interested in buying this property and they do a title search, they could see that there's been a lis pendens that's recorded. Would you want to buy a property that's getting foreclosed on?
No.
Well, if you do, you could get foreclosed on because now you become the owner who's getting foreclosed on because the lawsuit's against the property, not the property owner. So, yeah, you really want to do your research and do a title search before you buy any house. So, what is a lis pendens? It's a public notice of possible future legal action against the property because you're behind on your mortgage payments, for example. And it's usually a lender who records lis pendens in the public record. Can it be Can it be a good thing for you as a real estate agent in the business if you could get your hands on such a list of people who are behind in their mortgage payments? Or as a real estate investor, or as a real estate agent? Could that be beneficial for you to get your hands on it and know who's behind on their mortgage payments?
As an investor, yes.
Well, not as a real estate agent?
Well,
These are people that may be possibly getting foreclosed on because they've fallen behind in their mortgage payments. If you reach out to them, you could say, hey, you've fallen behind in your mortgage payments. I could help you get out of this. You know that you're going to, if you can't get caught up, you know that you're going to lose this property. But if you try selling it, I could help you try to sell it now. If we have enough time, we could get you as much money as possible for market value of the property. But if you wait till the last second, then it's just a matter of just trying to sell it to avoid foreclosure, and you may not get top dollar, but at least you won't have a foreclosure on your credit, and you can walk away with some money in your pocket. All right. Now, what if you're behind on your mortgage payments because the house is not worth what you owe on it? You owe more money on the house than it's worth. This does happen. When we had the mortgage financial crisis and the mortgage meltdown and the market crash of 2006, yes, it happened in 2006. I don't care who says it happened in 2008. The mortgage market did not crash in 2008. That's when the first bailouts started by politicians to try to stop it, because the decline had already been happening for 2 years, or almost 2 years. It happened in late 2006. The market bubble officially bursts, and the real estate prices that were artificially inflated due to various reasons and incentives by politicians to ignore their banking regulations, because they claimed as the reason poor people and minorities needed to get loans to buy homes. This was Barney Frank did this. He was the head of he was in charge of the Banking Oversight Committee in Congress. And his job was, provide oversight. So instead, what he did is he, on these C-SPAN meeting, hearings you could watch on C-SPAN, he was chastising the lenders or the oversight of people, his own investigators. He was in the banking industry. He was like, why aren't banks writing more loans to poor people and minorities? And he did it with this lisp, and it's kind of annoying. Anyway, he was yelling at them about why aren't there more loans being written to poor people and minorities? He's like, well, we're the investigators. We don't write the loans, but how does it work in banking? Well, in lending, it works like this. People come to a bank to get a loan. Banks don't drag people into the front door to get a loan. It's whoever walks in and asks for the loan, and then they need to qualify for the loan and meet the qualifications. So you need to have qualifications are generally based on people's DTI, their debt to income ratios, how much money they're making in relation to what their current debts situation is. And then the lender will only lend them a percentage of that. They're not going to lend you 100% of your income. They're going to lend you based on how much you could afford to pay monthly. Now, it'll also take into consideration your credit score too, your history of paying back loans. That could affect things as your interest rate, and if they're going to give you the loan at all, because if your credit score is under a certain amount, you may not even be able to qualify to get a loan. And he was like, I don't want to hear any of that. He's like, if banks don't start giving more loans to poor people and minorities, then they're engaging in racist activities, and we're gonna fine them, and we may even revoke their licenses. That's the way the guy was talking. So banks were listening, and banks said, you're gonna fine us and revoke our licenses if we don't give more loans to poor people and minorities. Okay, well, poor people, they can't afford much because they're poor. So how do we get more loans for poor people? We got to lower our lending standards. Now, let me ask you a question, a little common sense here. If you lower your lending standards so that people who previously could not afford to get a loan now can, what does that do for people who previously could afford to get a loan? Because the standards were lowered. How does that affect people who previously could afford a loan? They can borrow more. Right? I mean, common sense will tell you that. If you could previously afford a loan, now they lowered the lending standards, that means that you could borrow even more. You could qualify for more.
Wouldn't it also raise the property price because
Wait, because of what?
the loans are easy to get?
Okay, well, okay, because the loans are easy to get. Okay, well, that just deals with who can get the loan. So they lowered the lending standards, so previous people who couldn't qualify for loans can now get them, and previous people who could qualify can borrow more. So if a homeowner knows that people can afford more, what are they going to want for their house?
More money.
Common sense, right? I mean, I'm not making some weird conspiracy stuff up here, right? I mean, this is common sense. Okay, and that's actually what happened. And this was actually one of the factors where you could see when he did that, there was actually a spike. You guys got all familiar with how to understand reading a curve with the whole COVID thing, right? So when he did that with that threatening of the banks, and they started putting all these programs into place that made it so that people who previously couldn't afford a loan can now get it by lowering lending standards, or even in some cases removing you having to prove what your income or assets were, thus lowering the lending standard. People could afford a lot more. People who previously couldn't qualify could get loans. I mean, you're getting bus drivers out there claiming they make $300,000 a year, you know, because there was loans called no doc, stated income, stated assets. You didn't have to even show how much money you made. Now, after a while, it was getting a little bit crazy. So the banks started putting in there, well, it needs to make sense. You can't have bus drivers claiming they're making 300 grand unless they can prove it, you know, because I mean, what kind of bus driver is making 300 grand a year, you know? So they, you know, but either way, you could immediately see that curve was a spike where the property values started going up like this because people wanted more money for the house, and people are borrowing it. It ain't their money. So what do they care about paying more for it as long as they can afford the monthly mortgage payment? So people are only looking at the short term like they usually do. Can I afford the monthly payment? That's like when you shop for a car. See the price of cars lately? Who the hell can afford to pay 100 grand for a car? You know, or even $60,000, $70,000 for a car. It's insane. You know, so people just break it down to, and if you ever go to a car dealership, they're always breaking it down to the minimus. You know, what's the monthly payment? They don't want you to negotiate with them on the overall price. They want to just make the monthly payment affordable to you. That way, they'll just lengthen the term of repayment. And then they end up making more on interest and everything and on the loan anyway. You know, that's not the good way to buy stuff. You don't go by the monthly payment. You negotiate the overall price. So when you go to car dealerships and stuff, don't let them pull that crap with you. Even if you're leasing a vehicle, negotiate the overall price of the vehicle, not the monthly payment. Okay. Then they may want to make it even more affordable by making the down payment larger. Okay. But either way, you saw that those prices spiked up Okay, eventually in 2006, the market had enough and the bubble burst and prices started going down. And that's when we had politicians then start stepping in, trying to correct the problem by doing bailouts and then by offering tax benefits for anybody who'd rushed out and buy a home in 2008, 2009, 2010. They offered I think it was $7,500 tax credit for anybody who rushed out to buy a home for a year within that year, you know. So people rushed out to buy a home. And when they rushed out to buy a home, the curve flattened a little bit. But after the end of that year, the markets continued to correct themselves and it dropped again. Okay. The values started dropping again. So politicians, in all their arrogance, they said, oh, we had the solution to the problem. We just didn't throw enough money at the problem. So let's do it again. This time we're going to offer $11,000 tax credit. So now you had even more people rushing out. So that curve that was dropping all of a sudden started flattening and it was almost straight until the tax credit went away and then the buyers went away. The market kept correcting itself. All the politicians managed to do was delay the inevitable and draw out that market correction and pull more people into financial hardship, the ones that they incentivized to rush out and buy a home, because they started getting scared once they bought a house and they saw the property values drop. They saw that the tax credit that they were given, they were like, oh, that should be enough to make up for the market fall. And when it was getting close that it was being used up and the property values dropped so much, they wanted to get out of ownership, so they didn't lose their shirt on it. So they started selling the house.
Was the loan that easy to get in those years when they
Yes,
still there?
yes.
Wow.
Yes.
Okay.
You could get these. Oh, wait. Oh, you mean after the market started crashing? It
Yes.
started getting a little bit harder to get the loans for the houses too.
Okay.
But they still had a lot of those no doc or low doc loans. And they were also pushing products like adjustable rate mortgages, which have these teaser rates for the first 5 or 7 years that you own a property. You got a really super low interest rate. So people would qualify for the loan at that super low interest rate. However, if interest rates do rise, well, they were already maxed out of what they could afford on that low interest rate.
Yep.
A lot of people were thinking that, wait a minute, if I get a loan, property values are going up. This was before the market crash. They were like, oh, property values are going up. I'll just refinance into a fixed rate loan by then because I'll have enough equity in the property. It doesn't have to be me making payments on the loan that build equity. If property values keep going up, I could build equity too. As long as I got 20% equity, I could I could refinance into a fixed rate loan. So people were buying houses during that upswing period too, with those adjustable rate mortgages with the teaser rates, knowing that when they do adjust, they're no longer going to be able to afford those loans anymore. So they were kind of gambling, weren't they? Knowing that they're going to adjust and the interest rates are going to go up at some point, but they're already maxed out on what they can afford to pay at the lower interest rate amount.
At least for the 5 years, 7 years. Yeah.
Well, the thing is, there was 3-year, 5-year, and 7-year adjustable rate mortgages. So when some of these started coming to adjust, it started making the market crash even more because the people couldn't afford the payment anymore. And now you couldn't refinance either because the prices were coming down. The market was crashing already. So who's going to give you a loan to pay off? Refinancing is getting a new loan to pay off your existing one, hopefully at a lower interest rate, right?
But that you can see
or from
until
an adjustable rate loan to a fixed rate loan. Now, who's going to give you a loan for a property when the property's not worth how much you want to borrow?
But wouldn't that you see in like year of 2012, 2013 with the 5-year or 7-year of farms?
Well,
Given in the
well,
2000.
people may have gotten some of those loans beforehand, before the market crash.
Okay.
A couple of years before even, So once again, those loans, they're 3-year, 5-year, 7-year, right? And if the market values start falling, people are like, oh my God, I need to refinance. Who's going to refinance a loan where the house isn't worth it? Who's going to lend you more money than the house is worth? You know, if you need to have the collateral for it. The collateral is the value of the house. The house isn't worth it. Why is somebody going to lend you that much money? If you default on them, how are they going to get it back? There's no security there. Doesn't make sense. So those markets just crashed, and it was reason after reason after reason, and it all can be traced back to political decisions that politicians make. You know, they won't admit it. You know, they'll fight you tooth and nail that it wasn't our fault. It was the banks. It was the realtors. It was the attorneys. It was the lenders. It was, oh, wait, it was the appraisers because they were appraising them. Well, appraisals are based on sales, and if their sales were getting made, you know. So there was a lot of people that were getting blamed for it, but it could all be traced back to the politicians. You know, the banks have to take some of the blame. You know, even though they were forced to do it by the politicians, you know, they put a lot of these programs in place to try to, you know, lure in lower income to meet that threat requirement. Now, how did they address the issue about getting more minority people to get loans? Well, they targeted them in, I don't know, in the areas where there's higher minority populations, maybe in the magazines or TV programs they watch, whatever, you know, they tried to target minority groups. And this became known as predatory lending later on. Okay. But they were kind of forced to do it. They were threatened, actually. But either way, they engaged in it. So everybody got plenty of blame to go around. Anyway, we'll get into that stuff in the mortgage chapter. I usually give that explanation, that whole story in the mortgage chapter, but I gave it here. So lis pendens is that public notice of possible future legal action. And if you could get a list of people who are in danger of getting foreclosed on, you could do these short sales for them. So just like when the market was crashing and people were trying to sell homes, but the house was not worth what they owed, they put their head in the sand and they're like, I can't sell my home. There's no way I could pay back what I owe on the loan. So it doesn't make sense to try to sell the home, right? The bank will still be able to come after me. Well, let me ask you a question. If you're a seller and if you're a homeowner in that situation, you owe more on the mortgage loan than the house is currently worth. You think that there's nothing you could do. There's no way, even if I sell my house for market value, it's not going to be enough to pay off what I owe the lender. What if I stepped in the picture as your real estate agent and I said, hey, I got you. What if I told you that I could sell your home at whatever the current market value is, and I could get the lender off your back? I could get them to agree to take whatever the current market value is and not chase after you for any deficiency. Would you find value in that?
Yes.
Absolutely. Would that relieve a burden for you? Absolutely.
Yeah.
Now, you're worrying about my commission. You're worrying about my fee, aren't you?
What's the catch in there?
Don't worry about my commission, because what if I were to tell you I could negotiate with your lender to get them to agree to pay my commission instead of you? Would you find value in that?
Of course.
But isn't that
You're gonna need a lawyer. Hold on. You're going to need a lawyer in this transaction too, for doing the sale and negotiating with the banks and making sure everything's done properly as well. I know you don't got the money for the lawyer either, right? So what if I were to tell you that I could negotiate, that I could get your bank to pay your lawyer's fee to do the short sale? Would you find value in that?
Yes.
Now, in certain circumstances, depending on where your bank got the money from to give you the loan, I also may be able to negotiate with your bank to give you some money, to give you several $1,000s to work with them to do this short sale. So when it closes, they'll give you several $1,000s so that you could relocate and get out of there and go somewhere else. Would you find value in me negotiating the bank giving you a couple thousand? Look, otherwise, I mean, you'd be getting foreclosed on and getting getting your butt kicked out on the street with nothing anyway. You know, I'm negotiating that I could negotiate with the bank for you that they're going to accept it free and clear, and they're going to record in the public record that everything is paid, settled, less than the full amount owed. That's how it's going to show in your credit report. No foreclosure. They're going to pay my fee. They're going to pay your attorney's fee, and I may even be able to get them to give you some money. So yeah, that's a great deal, right? What was your question? Who was that? Vincent? Is it Vincente or Vincent? Vincente, right? You had a question? No.
No, I might have just hit it by accident.
Oh, who
What
had
is the catch in that? Oh, yeah, it was me. But what is the
okay.
catch in that?
Okay. So what was the question?
What's the catch in that?
There is no catch. I could do that.
So
could do
why
that.
would lender,
But most people don't know about this stuff. This is why real estate agents were sending out postcards and mailings to people who are behind in their mortgage payments.
so let's talk about the lender here, right?
Mm-hmm.
Why would lender accept a less money and taking the loss on the loan,
What's their option?
on the principal?
What's their option? To foreclose on you? Foreclosure is an expensive, long, drawn-out process. On average, it would cost them $50,000 with attorney's fees, with holding costs, with trying to get the property back from you. By the time they get it out, you probably stripped it or damaged it because you're all pissed off as a seller who's as an owner who got their property taken from them. So you're probably doing damage to the property. Or if you just abandoned it, some other people are going to come in, maybe party in the house and destroy it, you know. But if you stay in that house and you're maintaining that house and you're working with the lender to sell that house, they could sell it a lot quicker than going through foreclosure and then listing it with a real estate agent and having to pay their fee anyway and paying attorney. Now, instead, this will save them money. This is why short sale process is long and drawn out. They have to sign, a bank has to assign a negotiator to it, and they have to run the numbers. They have to see, would it make more sense just to foreclose on this person? Would we get more money that way? Or does it make more sense just to do the short sale? Okay, so they do analyze that. That's why you got a lot of people that were buyers that they're like, oh, you could go out there and offer anything for a short sale. You could offer way less than half the price of the house and get it. No, only if the market value was close to that. They may be willing to take a little loss, but not that much. They're not stupid. If that's the case, they'll just foreclose, get the property back, list it at whatever the current market value is, and wait to get the most money that they can for the house. They're willing to take a little bit of a loss because time is money too. They want that money, and cash flow is a way that they use cash to lend to make more money. So the sooner they could get that cash back, it's worth more to them. So this is why they're willing to take a little bit of a loss, and they had no problem with doing this. Good.
Yep.
There's courses you could take for that. We went over some of them in chapter 3 called the CDPE, Certified Distressed Property Expert, that used to be offered through the Sharfrin Institute. And now it's somebody else bought that course from that guy, and somebody else is offering it now. I don't know if it's as good as it used to be, but CDPE, Certified Distressed Property Expert, is a course that taught you really good about, it was a good designation to get to specialize in short sales. I learned by doing, and then I eventually took the CDPE course, and then they canceled it. So now I got no CDPE designation anymore, but whatever. Then you have the, NAR has the SFR, Short Sale Foreclosure Resource Training course. I think touches on those things and teaches you how to do it as well. Don't know the quality of that course, never took it. All right. So list pendants, yeah, you can get those list pendants lists. And I give you two resources where you could get access to some of that information. Although if you're a member of the Garden State MLS, they also give you access to a program called, what is that program called? Hold on, I just took a course the other day. I'll call Remine. I got my notes here from the class that I took the other day after I was teaching you guys. Called Remine Pro, which you get free of charge with your dues for your membership in the Garden State MLS. They give you this tool called Remine Pro, which allows you to search the MLSs using a lot of tools, but it also searches tax records, including foreclosure records and such. These ones search the public records. I think these ones may be better as far as list pendants. I haven't tried out the Remine for looking at list pendants yet, but njlistpendants.com or RealtyTrack. But RealtyTrack doesn't just include list pendants information, it also includes foreclosure and REO. REO is real estate owned by a bank that has already been foreclosed on, and now it's owned free and clear by the bank. Those banks will relist those properties for sale, usually with a real estate agent, to try to sell the property. So the fees may vary differently from both of these, but either way, they both carry list pendants lists. They've got people that go down, they search those data, they go down and they create a database based off of the information. The moment that it gets filed in the and recorded in the public records down at the County Hall of Records in each of the 21 counties within the state, they got people that are stationed down there, or maybe it's that secretary that works for the, that's in charge of the public record keeping. They're getting a job on the side there to enter it into another database, which then gets sold, that information gets sold. Otherwise, you'd need to know how to go down, search the public records and find this information in the public records. So the database is easier to subscribe to, and you get that information. You could get a list, an updated list, anytime somebody gets added to this list pendants list. So it's a public notice of possible future legal action, foreclosure, that's pending and may potentially affect title to a specific parcel of real estate. It gives notice to all interested parties, including prospective purchasers, that someone has an interest in the property. Lenders will place a list pendants in the public records when an owner falls behind on their mortgage payments to put the world on notice that a possible future legal action, foreclosure, may be coming soon. So here's some resources if you guys want to subscribe to one of those list pendants lists. You know who else may have a list pendants list that you could subscribe to? Actually, there may be another one you could add there. It's a tool that I told you guys about. And the name of that tool is slipping my brain right now. But I can look it up real quick. Okay, so the Red X, that's the tool, that's another tool where I think that they could also mine, and you pay a fee for this as well to get those access to those to those list pendants lists. But I know RealtyTrack is a solid one. It's up to date, it's always accurate. All right. So you send them a mailing. Don't go knocking on these people's doors or even giving them a phone call. Yeah, you're behind on your mortgage payments. They're gonna be like, wait, who is this? How do you know about my payments? Or they're gonna be angry, you know. Do a soft introduction. Send them a postcard. Behind on your mortgage payments? We can help. You know, and continuously do it, because they may not respond to the first time because they think that they'll get caught up. And sometimes they do. Sometimes they do get caught up. But there are a lot of people that get on these lists that never get off of them. They'll either get foreclosed on, they just don't know the writing's on the wall yet. So keep sending them these postcards, you know, or mailings, letting them know. All right. Easement is a right acquired by one party to use the land of another for a specific purpose. Now, if you have rights, nobody can take your rights from you. They're yours. So it is a right acquired by one party to use the land of another for particular purposes, an easement. Underline the word right. And an easement may be either a pertinent or in gross. An easement in gross is basically a utility easement. We're going to get for public utilities. We're going to start getting into all the different types of easements in a moment. Right now, just write next to easements, rights can't be revoked. And an easement is a right, and underline the word right, acquired by one party. Do you value your rights? I should hope so. You know, so your rights, once it's been established, you have rights. Your rights cannot be taken from you unless you give up your rights. Like you commit a crime, a felony. Felonies, you lose some of your rights. You lose the right to vote. You lose certain rights. And there should be punishments for actions like that. But otherwise, people can't take away your rights. You could give them up. You have the right to remain silent. Should you give up that right, so you could give up those rights. So there's various ways that people can give up their rights or lose them if they commit a crime. But other than that, your rights cannot be taken from you. Everybody got these notes here?
Yeah.
Got it.
So easement is a right acquired by one party of land or one party to use the land of another for a specific purpose. Once you have a right, once it's been established, you have rights. Nobody can revoke them. Nobody can take away your rights. Now, easements, they could either be appurtenant or engross. We're going to learn what that means in a moment. So, an easement that grants the right to the owner of an adjacent parcel of land, that's your neighbor whose property is touching yours, not the person across the street. So an easement that grants the right of an owner of an adjacent parcel of land is an easement appurtenant. An easement appurtenants are always going to have two parties involved. The one who benefits from that easement, who's getting to cross your land, well, let's take a look at it. The owner whose land is being crossed over is known as the servient estate because they're serving their property up on a platter for someone else to cross over. And the one who's benefiting from that easement is known as the dominant estate. So for an easement appurtenant to exist, there must be two adjacent tracts of land owned by different parties. The tract over which the easement runs is known as the servient estate, and the tract that is to benefit from the easement is known as the dominant estate. Let me give you I'll give you a couple of simple examples with drawings even in the coming slides. Let's just first do the highlights here, and then we'll discuss it a little bit further, okay? An easement is said to run with the land. Once it's created, it moves on from one owner to the next. An easement in gross is a utility easement, for like public utilities, like the gas lines, sewer lines, electric, telephone poles, you name it. So if the need for this easement were to cease, the easement would cease to exist. That sentence only applies to an easement in gross. That's the only type of easement where the easement would cease to exist if the need for it was no longer there. So, easement in gross is a utility easement. Okay, so let me know when you got all the highlights and notes.
Got it.
So, easements are either appurtenant or in gross. You have an easement is a right acquired by one party to use the land of another for a specific purpose. Now, these are the types of easements and the things that we're going to be going over in a moment. Easement appurtenant, easement by necessity, which is also an easement appurtenant, easement by prescription, an easement in gross, party wall easement agreements, how to create an easement and how to terminate one. So once again, an easement is a right. It's usually put in writing, written into the deed itself, or into a survey. And these rights cannot be taken away once it's been established that you have them. However, a license, on the other hand, is permission to enter the land of another for a specific purpose. This is often verbal and it can be revoked at any time. All right, so go to page 112 and highlight that license and, well, actually, hold on a second. Yeah, there we go. Page 112, highlight this and write that. You already did this on 109. So go to page 112 and do that, and then come back to 109. All right, or 110, actually. So an easement is a right acquired by one party to use the land of another for a particular purpose. This easement will run with the land. That means it passes from one owner to the next, even when the ownership is changed. Now, a party could also have an easement right in the air above the land or subsurface easement rights to what's beneath it, whether it's just the space or the minerals in the ground. That doesn't mean that they have rights of ownership, that they only have rights to use it. The holder of an easement only has rights, not an estate or ownership interest in the land over which that easement exists. So easements fall into two categories, either appurtenant or in gross. What is an easement in gross?
The utility easement.
And an easement appurtenant is two adjacent parcels of land owned by different parties. There's a dominant estate and a servient estate. Which one benefits from that easement?
The dominant.
The dominant. So an easement is said to run with the land. If you didn't have that highlighted, that's on page 110 where you would. So in this drawing on page 110, you have an easement appurtenant right here. You have lot owner B on the left, lot owner A on the right. You have an easement appurtenant that was created so that lot owner B can cross over lot owner A's property to use the lake. Who's the dominant and who's the servient estate in that regard for the easement appurtenant here?
B is the dominant.
Correct, because they're benefiting from this easement because they get the use of the lake. And A's property is being walked over, so they're serving it up on a platter. Now, they can't stop B from crossing over onto their property and using that lake because they have a right, and that right cannot be revoked by this landowner A. So the dominant estate's the one that benefits from the easement, and they are the only one that can terminate it or give up their easement rights. The servient estate is the landowner whose property is being used. Now, an easement in gross is a public utility easement. And if that easement, that need for that easement were to cease, the easement would cease to exist. We already highlighted this. This is just showing you an easement in gross here in this image would be the telephone poles or power lines, whatever that is, crossing over all these property owners' property. Okay. We need an easement in gross. Otherwise, you'd always get property owners that stand in the way and say, oh, you know, they want to run the power lines there or the gas lines across my property to get it to the big city. I'm going to charge them a gazillion dollars. You know, look at that. I sound like Joe Biden, right? $100 gazillion. So, a million bagazillion dollars. If they want to get that right. No, you're not. Because it's for the greater good of the public. The law says utility companies, if they need that for the greater good, they have the right to take that property and then justly compensate you. So they do have the right of eminent domain as well. Now, an easement by necessity is when it's necessary to gain access to a landlocked property. There's no other way to get to your property. An easement by necessity would be created because it's necessary to cross over someone else's property to get to yours. It is a type of easement that is used for the purpose of ingress and egress. Ingress means entrance, egress means exit. So here we go. Easement by necessity, a necessary easement to gain access to landlocked properties for the purpose of ingress and egress. You can get those highlights down if you will.
Got it.
Now, this is a bad example in this photo here. Unless you're in a place where you got a bunch of tree huggers that they don't allow you to cut down a tree to put a driveway to get to your own property. All right. So let's just say you're living in that kind of fairy tale land, and the only way to get to your road then would be to cross over your neighbor's property and build a driveway over their property to get to yours. Okay, then it's necessary. So this is a bad example, but I got a couple better ones coming up. Okay, here's an example that's better. You got lot owner A and lot owner B. Lot owner B's property is completely surrounded by lot owner A. This does actually happen in real life. You figured that it wouldn't, but for some reason it does. So there's a roadway here to get to lot owner B's property. That roadway, that's not a driveway, or you call it a driveway, roadway, whatever you want. Lot owner B can't just park their car and leave it there. That's not their property. It's lot owner A's property. They could only use it for the purpose of ingress and egress, to get on and off of their property, to get in and out. Now, who's responsible for maintaining the road? Shoveling the snow and whatnot.
Lot owner A.
Yeah, why is that?
It's their property.
That's right. Even though lot owner B has a right to cross over it, lot owner A has to maintain it. And they have to make sure it's not obstructed at all. Any trees fall over or, snow there, because they need to make sure that they have that clear right of way. Otherwise, they are kind of interfering with their access rights. So this is the most common type of, this is a type of situation that it's blaringly obvious why there's a need for lot owner B to cross over lot owner A's property. Here's a common one that we see: shared driveways. Right, you got two houses close to each other. Neither one of them has enough room to get to the garage that's in their back. So they put a driveway that's partially on both properties, and then it splits off where they got the driveway in the backyard of each house and maybe a garage back there too. Okay, so who's the dominant estate and who's the servient estate here?
Both.
Correct. They're both dominant and servient at the same time because they're partially using each other's property. Now, often when you see this, you'll usually see that maybe the driveway is more on one lot than the other. And then you get one of these owners that gets a stick up their butt, with this attitude that it's more on my property, so it's my driveway. I allow you to cross over it. Well, you know what? That's not a good neighbor. Those are people that are going to be feuding constantly when you get a jerk like that. But they can't put up a fence there to prevent you from going in or putting a lock on it, because now they're violating your easement right. These should be good neighbors. If they don't have good neighbors in situations like this, it is a nightmare situation to deal with. But either way, yeah, this is another example that we often see in congested areas where there's an easement by necessity to get onto your property. It's necessary to cross over the neighbor's property, even if partially, to get to your own. All right, let's go over that easement by prescription again here, also known as adverse possession. When you use someone else's property for a period of time as defined or prescribed by state law, you could claim ownership rights of that property that's being used. Now, to perfect this easement and to gain that ownership, it does require a court action called a suit for quiet title or a suit for adverse possession. Either one is fine. The whole idea is the lawsuit, the purpose of the lawsuit is to prove your claims so that you can claim the ownership. Just because you use somebody's property for a period of time as defined by law does not automatically make you the owner. You have to file that claim. So the use must be continuous, hostile, adverse to the owner's title, exclusive, and without the owner's approval. Additionally, the use must be visible, open, and notorious. So the prescriptive period in New Jersey is 30 years for improved lands and 60 years for unimproved lands or wetlands. That's going to change at some time in the future to 20 years because there's also another law in the book for 20 years. But in the meantime, on your state exam, if you get a question about this, 30 years is the prescriptive period for improved lands, 60 years for unimproved. Until they change the law, that's what it is, and that's what it's always been. So let's go with that. Now, through the process known as tacking, successors in interest can tack on their time to another person's time, combining those two time periods to reach a prescriptive period where they can make a claim of adverse possession. But they have to be successors in interest of some sort, like a landlord and a tenant, an ancestor and an heir, seller and a buyer. They could add on that one person's time to the others, combining them to reach that prescriptive period. But an owner can prevent somebody from gaining an easement by prescription by taking action against any adverse possessors that they're aware of that are using their property. Remember, it has to be continuous, hostile, adverse to the owner's title, exclusive, and without the owner's approval. Additionally, it must be visible, open, and notorious that they're using the property. So basically, the owner is aware you're using it. They're always complaining about it. They don't like it. They didn't approve it, but they're not taking any action to get you removed. If that's the case, and somebody files a claim of adverse possession, they could win it. It's your property. You've got to protect your property. Now, you could cut off their access, maybe put up a fence or something that stops their use of that area. That resets the time clock, or give them permission to use the property and then take the action to get them removed after that permission period is expired. You send them a certified letter through your attorneys or whatever. Giving them permission until the end of the week or the end of the month. You're resetting the time clock, so now they can't, if they didn't start a lawsuit for adverse prescription yet, for easement by prescription yet, for adverse possession, then they're not gonna be able to, because you gave them permission already before they ever established a claim. And then you could start taking legal action to get them removed. And also remember, you could never get an easement by prescription against publicly owned lands. I'll give you an example of that in a moment. I had a listing of that one, like that once. So let's highlight the notes for easement by prescription on page 110 and 111. We already did this later on in the later chapter, but this is on page 110 and 111. These are the things to highlight. Let me know when you guys got them highlighted and the notes written in.
Got it.
Got it.
All right.
Got it.
Anybody else need another minute, or everybody good? Good. And then this is what we already highlighted in chapter 20 pertaining to adverse possession. And And once again, I told you that nobody's going to gain an easement by prescription through adverse possession these days because there's a conflict in the law. Our politicians wrote too many laws without checking to see if there was already a law on the topic, or they didn't care because, I don't know, maybe somebody was trying to make some kind of claim to fame of what they did, you know, trying to build a record for themselves. And they made a law about something that there was already a law about. Happens all the time. You could look at Congress, you could see them doing it all the time, right? So our New Jersey legislature, they're no different. They're politicians, self-serving.
Isn't it is not bad to have 20 years and 30 years?
Well, there's a 30-year and 60-year and a 20-year on the books.
But the longer the time, the better it's for the property owner, no?
Yes. But let me see. That's a long time.
So I'm not sure why the politicians are advocating for 20 years.
Why wouldn't you take action against somebody for over, let's just say it's 20 years?
No, yeah, definitely you should take it even in 1 year, right?
Yeah,
But
I
given
mean,
like there are long-term
you know,
leases,
property without your permission and you don't want them there, get them off your property. Take action to get them removed. What do?
file a case against them, yeah.
Call the cops. Get them off my property. They're trespassing. Get them off my property. Put up trespass signs. Let's just say that it's not just your regular city block, your city lot. Let's just say that you own 1,000 acres of land. Okay. You should walk the boundaries or drive the boundaries, ride a horse, whatever, to go your boundaries and check your property at least once every 20 years, right? And take action against anybody that's there without your permission.
Yeah.
If not, do you really need all that land? If somebody else is using it and they want to claim ownership and willing to pay taxes for it, oh well. And if you're adamant that, well, that's my land, I don't want them having it, well, then walk your damn boundaries and protect your property. What do you want me to say, right? I mean, does that make sense, though?
Yeah, but the question was more like, I mean, politicians doing it 20 years is bad
Why?
because then the person can claim the ownership in 20 years rather than the 30 years.
So what? Some states have 7 years
Oh, wow, okay.
or less. Like Florida has 7 years. Different states have different time periods, you know.
Okay.
Like you said, it doesn't matter if it's a year.
Yeah.
Get them off your property. I mean, the longer periods of time may be more reasonable if you own hundreds or thousands of acres of land, you know. But if you got that kind of money, fly over it with your helicopter, or take a horse, or a ATV, or go for a hike and hike all of these acreage of your property and make sure there's nobody on it, and take any action against any adverse possessors that you don't want to be on it. So we got all that highlighted, right? And then once again, that inverse condemnation is when a government puts in so many regulations as to how you could use your property that they basically render it useless. They're basically taking away the value of your property. Then you could sue the government for inverse condemnation. Look, I had a situation in class a couple of years back. I had a broker's class I was teaching, and one of the guys during the broker's class, he was always on his phone, and he moved to the back. He said, "Oh, I got to deal with a client." So he's like always on his phone and stuff. And then he's like, "Vic, what do? I got this problem here." And I was like, "Well, what's the problem?" He's like, "I got this guy. He's a developer. He borrowed money to buy this land and then to do the construction project to build so many homes, and he has to build so many homes in order for it to pay for itself, let alone, you know, turn a profit." And at the time, President Obama gave the EPA all kinds of additional broad sweeping powers that they did not previously have. They abused the hell out of it. You know, you would think the EPA, you know, they're there to protect the environment. What are they going to do? They're not going to harm property owners and all that stuff, you know. But anyway, in this one instance, they passed something that had to deal with the trees and the lay of the land, and it basically turned into this guy's project that now he could only build on half of his land, not all of it. So basically, he got this whole project approved to be built, but he never recorded the approvals that he got. And when President Obama called for these, gave the powers to the EPA then put through a moratorium on any construction in these areas. A halt to any construction that's going on. That's what a moratorium is. Now, if you have approvals to do construction and you recorded them in the public record, even if the government calls for a moratorium, a halt to all development in the area, you could still start your project and build. But if you got all the approvals, but you didn't record them, and they call a moratorium, then you can't. So basically, they put so many restrictions in place that he can't build that enough to pay back the money that's owed, let alone turn a profit now. He's like, Vic, what do I do? He's like, this guy keeps calling me. He's going crazy here. He borrowed money from the kind of people you don't want to owe money to, you know. I guess that's like a mafia signal or whatever, you know, the mob. And, you know, he's like, he owes money, you know, he's got to pay this back. I mean, the guy's, he's talking about killing himself. What do you do? I was like, oh, I don't, first of all, I don't do nothing. I don't want to get involved in this situation right here. Yeah, you know, where you're borrowing money from people like that. And I'm not tuning in on this, but here, let's give this. That developer, he got all of his plans approved, right? But they didn't record it. Whose job was it to record those approvals? It was his, or did he put those plans on his attorney? Was his attorney responsible for recording them? If so, he should have insurance that you could sue the attorney's insurance, you know. If not, I mean, it's the federal government. At the time, back then when that happened, I wasn't thinking about inverse condemnation as an idea, but actually, now that we're talking about it, inverse condemnation would be a pretty good idea. The developer could have sued the EPA, the federal government, for putting so many restrictions on his property that he's not able to use it or develop it. And they're basically devaluing the property, aren't they? So they could sue the government to get paid back the money for the loss, to get compensated. Because the government is basically taking away the owner's rights to do what they want on their own property. And if you're going to do that, you need to compensate them for that loss. So unfortunately, I didn't think of it at the time back then. But this was actually, I was just thinking of it now, that this would be a good, that would have been a good option for him. I don't know whatever happened with that, but by the way. But also, there's a mayor in a town that was talking about they like to keep the old world town feel of Metuchen. And I was talking to the mayor there because they were talking about this one lady who owns a lot of land there in Metuchen. And they have this, it's all commercial properties. It's called something park. I forget what it's called, but they're all commercial properties, all offices and whatever, but they all look like Victorian. Oh, it's Victorian Park. They all look like Victorian buildings and structures, and they want to keep that quaint old world town feel, despite the mayor approving all these other construction projects and building up of that downtown area, buying up all the stores that were there, tearing them down, putting up these luxury high rises all over the place and shopping centers and all kinds of crap. But yet they want to put they really want to put a restriction on this because a lot of people in town want to keep that old world feel about Metuchen and the town. And that park has all those old, beautiful Victorian homes there, even though they're being used as commercial properties, all those old, beautiful Victorian homes there. And so they were talking about how they could restrict and prevent the owner who's now talking about trying to do development and building up herself. As she's watching all these people making millions of dollars selling their properties to developers who are then building them up. Maybe she could build it up herself, right? And make even more of the property she already owns. And he's talking about a way to stop it. I'm like, whoa. I was like, you got to be careful if you do that, because she may be able to sue you for inverse condemnation then. Why are you restricting her, but not all those other developers there? Yeah, it also seems kind of punitive too. Well, we like the way that she has it. Okay, yeah, but it's her land. She should be able to do with it whatever the hell she wants with it, right? It's commercial property. Why can't she tear it down, put up another commercial building? They're more modern, get more rents for it and modernize it and everything. Oh, just because you like the old world feel, you know? So inverse condemnation, it's good if you know about these things, you know. This particular one, inverse condemnation, you're not getting on exam though, but I just wanted to bring up how having that knowledge could be useful to maybe clients or people that you're talking to, if you're involved in any government or other issues, you know, you may be able to use some of this knowledge for your benefit too, or to help others out. All right, now here's an example of a listing I had where the property owner owned this property in Piscataway, and there was a corner. It was a corner property. Now there was a city block over here and a city block over here, all with houses on it, and there was this block in the center here, and this was the last house on the block, and then there was a big grassy field over here next to it. Now the property owner was always using it. They even had a volleyball net set up on there because they used the lot. He used to cut the grass on that lot and maintain that lot for years because the city wasn't cutting the grass. But he made a point to tell me that that's actually the city's property right there. But he cuts the grass and they use it, and the city's never even been around there. So it was important that he told me that, because I did look it up on tax records, and I was going to bring it up as a question anyway when I pulled up tax maps. And I seen the lot there, and but he already said that this was the city. So it was important for me to put in the listing that the corner lot is not attached to the property and is owned by the city. Now, if he wanted to, he could try to go to the city and ask them to grant him the ownership of that corner lot. By public grant, the city could have given him the ownership of that lot. You know, he could say, listen, I've been cutting the grass here for years. I've been maintaining it for years. Nobody from the city ever comes out. Listen, if you give me this property for the corner lot, I'll continue doing that. And now you could collect more in property taxes for me because my property's bigger now. You know, I mean, the city has no use for that lot. You know, he could have built a case that way and asked them to grant him the ownership. And they could have. But they, you know, he never went that route, never did that. But that was one option. I'm building this scenario just to bring up all these different terms that we've gone over in class here. So you can't claim adverse possession against this property because he's been cutting the grass and been using it all these years. Now, what about this one? This entire thing is one person's property, right? And the street is out here. So they built a cul-de-sac. I didn't do a good job making this as round as a regular cul-de-sac street would be. But this is the street that they built going into his property off the main road. And then he subdivided his property into 6 lots and built 6 houses and sold the 6 houses. Are you going to keep that, if that's you, are you going to keep this cul-de-sac street private, that you own it? It's a private road. and you'll be responsible for maintaining it forever? Or would you dedicate it to the municipality after you sold all these houses? Or would you dedicate it to the municipality so that they're responsible for snow removal and fixing potholes and all that stuff from here on forth? Because it'll become a public road, even though you could name it.
Yeah, you dedicated.
You're dedicated. It's a headache. Why do you need it? You made your money, you sold all the lots, you don't need to own a street. You know, you got to name it. You can name it after yourself or a family member, whatever. You named it. And then you sold off all them lots, you dedicate this street. You don't need the headache of maintaining. All right, here. I got a little diversion here for you guys. Let's crank up the volume on this and see if you guys can get the answer. You ever hear Cash Cab? You guys ever watch that game show, Cash Cab? On TV? When it was on TV? Actually, I think you could see
Yep.
reruns on one of the game show networks. They're reruns, though, now. It's a pretty good show. Let's see if you could come up with the answer to this question.
What term for a
Well, let me crank up that volume. It's still too quiet. Wow. Juice it up a lot.
what term for a dead-end street means bottom of the bag in French?
What term for a dead-end street means bottom of the bag in French? Shout it out if you got the answer.
What term for a dead-end street means bottom of the bag in French?
Is it cul-de-sac?
Let's see.
Cul-de-sac. I'm afraid it is. Cul-de-sac is correct.
There you go. You won $50 if you were on that game show. All right. I got another one on the next slide. All right, so let me juice up the volume on this one. I don't know why these are so quiet. There, I got another one for you.
This next question was $50 each. What Chinese spatial philosophy used to determine sites for graves and
Did you guys hear that?
No.
It says, what Chinese spatial philosophy is used to determine sites for graves and house design?
Feng Shui.
This next question was
Let's see.
$50 each. What Chinese spatial philosophy used to determine sites for graves and that is correct.
There you go. You won $100 if you were on that game show. We're not giving out cash here, just having a little fun. So I don't know why that recording was so quiet. I had to juice up the volume, and it's still difficult for you guys to hear it. All right, so that was it. I only had 2 of them. But you see, when I hear these real estate terms, sometimes I'll bust out my cell phone and I'll record it off of TV and I'll put it here in class, you know. We see it all the time in movies and game shows, and you could be out there, people are having conversations, and you could hear these real estate terms being used a lot of times, or things that we need to know for real estate, like feng shui. Did you always know that it was used for layouts and to determine sites for graves? You know, feng shui, there's a class that I used to have. I used to hire an expert in feng shui to come in and teach a continuing education course that I offered about feng shui, because often developers these days, they do consult with real estate agents or experts in feng shui to assist them in their designing of real estate for homes, or for commercial real estate even. A lot of the principles of feng shui also match up with an Indian thing that's pretty similar. That's called Vastu. Okay, so Vastu and Feng Shui, they have a lot of very similar principles to them, even though their reasoning is different of why they follow these principles. But if you also follow the principle of common sense, a lot of those reasonings from Vastu and Feng Shui would make sense. You know, everything from how to design a layout of a room. Like, say you're putting an office together, where does the desk go? Do you want you to put your chair and have the desk with the window behind you or in front of you? Well, Feng Shui and Vastu, they have it so that the wall is behind you because the wall is sturdy. It's good for your back. You know, it's a nice solid backing for you. And plus, you get a beautiful view to look at out the window. Okay. So there's some common sense involved in it too, although their reasoning for it may be different. It could be religious reasons. It could be because a guru told you this. You have people that follow a lot of these different things, and you need to be aware of it. Even if you find it that it's silly or, oh, that's stupid or whatever, listen, it's the person who's buying the property. You need to know what's important to them. Don't dismiss it as being silly or stupid. It's because it's something you don't believe in, okay? You need to be aware of what's important to people in other cultures, even though the whole entire culture doesn't follow it. Like, I remember showing properties. I showed 1 million properties to this Indian guy, and he didn't buy any of them. They all met his needs too, you know, the price range, everything he's looking for, but, well, we're going to keep looking, we're going to keep looking. So I take him out one time, and he's there with like 4 of his other relatives, all men. They're all looking out to buy a house. You know, the one guy's looking to buy a house. So this last property that I showed him, looking at, I take the key and I'm locking the house back up, and I see them all huddled up in front of the porch, the front porch, and I'm like, what you guys doing over there? And they're all like huddled around like their cell phone. And they're like, oh, we're looking at the Compass app. Why? Oh, well, we want to see what direction the front door faces. Why? Oh, because if the front door is not facing in a certain direction, then we're not going to buy the house. You think you could have shared that with me as the real estate agent? I could now, if you told me that, maybe now I could search for homes that meet your criteria where the front door is facing that direction so that we could save each other a whole hell of a lot of time. You're finding all these houses that are perfect, but if the front door is not facing east for you, that you're not going to buy it, you know, I could have filtered that out. You know, I mean, that's not a feature that they put there in the MLS, but I could pull up the address on like a Google Streets or something, or Microsoft Bing Maps, you know, or Google Earth, and pull up the address and see what direction that front door is facing, you know, and it would save us a whole lot of time. You know, me setting up appointments, running you out, showing you properties, you know, you need to be aware and probably ask a few more questions when coaching people as buyers before you take them out to show them that first house. This is a perfect example. I showed this guy so many freaking homes only to find this out when they're all huddled up together. And I'm like, what are you doing? Why? Like a kid, you know, but that's what we got to do in order to find out, because sometimes people don't volunteer this information. It's like pulling teeth, you know. And I was like, son of a... So be aware of,
At the end?
yeah,
Did he buy at the end?
not that house. No.
Oh, but eventually did.
Oh yeah, I found them something eventually. But listen, by the way, when you're trying to find out what direction the front door faces and you got a compass, or you can download a compass app. Look, I even have 2 compass apps in my real estate apps on my cell phone. I have one that's
That's a
called,
building actually.
what is it? I got one that's just called a compass app. Oh wait, no, I got rid of the other one, I think.
iPhone has a built-in actually.
What's that?
iPhone has a built-in compass actually.
Oh, it does?
Yeah.
I got one that I downloaded called King Compass, and then I got another one called Vastu Compass. Okay. So either way, you have a compass. Now, how do you read which direction the front door faces? You don't face the door. Have your back to the door and see what direction the front door faces. Make sure that if there's wrought iron railings and things like that around the front of the house, take a couple steps away from the front door, because iron can mess with the magnetism in the area, and then it won't work as good on your cell phone. Okay, but this is something you should ask everybody, because anybody can follow feng shui or vastu. You don't have to be Indian or Asian in order to follow any of these principles. Just ask people, is there anything specific that you're looking for the house? Does it matter which direction the front door faces or anything? Now, people who follow these principles of Vastu or Feng Shui, numbers also play an issue with them too. Colors, numbers, is there a tree directly in front of the house? They won't buy it. If it's a street where it T-bones and then the house is right here, they won't buy it. If the architectural style has sharp edges out the front of the house where you can see the beams, put up a soffit. If a soffit is there, it's fine. But if there's no soffit and it's just that raw architectural style with the beams sticking out, they won't buy it. If you open up the front door and you can see the kitchen from the front door, they won't buy it. If the stairs going upstairs are immediately behind the front door, they won't buy it. There's a lot of things you need to consider. So you need to know if this is going to be important to your clients or not. So you got to probe them and ask them questions, things that you wouldn't have even thought just joining this real estate business to ask. You just take people out and it's price and how many bedrooms and baths, right? No, it could be more than that to some people. And you need to be aware of that. That makes you a better agent. You be attentive to their needs. Now, a lot of times people follow these principles. Numbers are an issue too. It could matter the address of the property. So you found them the perfect home, perfect price range, but oh no, they got advised that number is not good for them. Okay, so a lot of times in the Indian culture, I come across a lot of people that they're not even sure why they follow the principles. They just know that their guru gave them some kind of advice that told them that this is not good for them or that is good for them, and they should do this and that. And so the numbers, the address of the house or the date of the closing, can make a difference. The funny thing is with the date of the closing, they'll pick a date because they didn't like the number that we picked, and closings usually don't occur on the date that we pick. And then those dates get shuffled around a little bit, and then it closes on a day anyway. So, all right. So adverse possession and easement by prescription here. We have lot on the A on the left, lot B on the right. Here's where the actual property line is, and there's a fence right here. If that fence is there for 30 years because it's improved land, lot owner A can claim ownership of this strip of land here because they've been using it for 30 years. How can lot owner B stop them from gaining the ownership of this land right here? Well, they could take them to court to get them off of their property. They could give them permission to use it till the end of the month. Or they could cut off their access by putting up a fence where it actually belongs, right on the property line. Now, how did this fence get there and who put it there? Hey, it could have been lot owner B that put the fence inside their property line just trying to be a good neighbor because they weren't exactly sure where exactly the property line was. And then over the years, owners changed and they forgot who put the fence where and why that fence is there. Maybe surveys were not done. I don't know. It could be various reasons. This could be a few feet. This could be a few acres. Well, what are we talking about here, Could have been lot owner A put it there. I don't know. Don't assume who placed the fence there. It could have been a previous owner, the neighbor, etc. And now I'm going to play a little funny, humorous Benny Hill skit for you, if anybody remembers that guy. What happens when you assume? You
Because when you assume, you make an us out of you and me.
That guy was a genius. I love that guy, Benny Hill. Anyway, don't assume anything. All right, now here is here's a video. The recording is not the best, but the classes can make it out. And this is an attorney explaining how adverse possession occurs and what the legalities of it are. And what now, when trying to teach these classes, I try to get a lot of resources together to show to you for for learning purposes. And it is very hard to find information about adverse possession. And she even explains that here as the basis, the reasoning why she put together this article, which then it was some kind of article she put together in a legal publication for all attorneys to read and stuff. And she goes over it. Watch. There's some interesting information in here too. So.
For an attorney or for just a property owner, I think a lot of times people don't even realize that this body of law exists. Maybe when you own your first home or you get your first survey, you start to realize how important boundaries can be.
Can everybody hear that?
It's a little muffled, but I hear.
It's a little bit muffled, but you can hear it though. Okay. Let me try to correct it the best I can. I'll try to juice it up a little bit more, but yeah, sorry for the quality of the recording. That's the way it is online where I downloaded it from. But I'll see if I could try to clean it up some other time. But right now it's the best we got. So I'll raise the volume a little bit more.
As an attorney or for just a property owner, I think a lot of times people don't even realize that this body of law exists. Maybe when you own your first home or you get your first survey, you start to realize how important boundaries can be. My name is Jessica Shrestha. I'm an attorney at Wheeler, Van Sickle and Anderson. I'm here in Madison, Wisconsin. The concept of adverse possession is that the first you start, everyone has a deed to their property. There's a legal description, there's a boundary, whether it's a lot or something else, specific distances, and that's your boundary. But as everyone knows, it's hard to figure out where those are, and a lot of times actual occupation on the ground doesn't necessarily match the real boundary line. Sometimes it's a matter of a few inches, but sometimes it gets to be, we're talking feet, acres, a whole 40-acre parcel sometimes. And it turns out that if you occupy and use an area of property for long enough and treat it as your own property, the doctrine of adverse possession makes that your property by law. More complicated exactly how that applies, but that's the basic concept. Over time, property can become yours even if you don't have a deed. Adverse possession comes up most often for a typical property owner with a fence. It's really the classic example, and it has been for as long as we've had, real property and the law of adverse possession. Someone will construct a fence, and even if they get a survey to tell them exactly where the property line is, they might construct their fence a foot inside the property. They want to make sure they can stay on the other side, for example, or sit on the other side. Sometimes it's a greater distance, and over time they forget, or maybe they didn't know where the exact boundary was in the first place, and that fence might become the boundary by operation of adverse possession. Same thing goes with lines of trees and hedges. Or even people might place a shed on a neighbor's property. And that's in a city lot. The same thing though can happen with pasturing cattle or with fences for cropland.
That's why it's important to get a survey when you're buying a property so that you know where the property. A lot of times we get buyers, they ask us when they're searching for a property where the property line is, if there's no fence there, or even if there is a fence. Is it where the ground contour changes, or is it where the row of bushes or trees are? It's impossible to tell without a competent surveyor coming out and measuring the land and doing a survey for you.
And a potential new client comes to me and they think they have a boundary dispute or maybe an adverse possession situation. To start, I think the easiest way to think about it is you have to ask the basic questions: who, what, when, where, why, and how. The who is really important. who are the parties involved? With adverse possession, it's not going to just be the current property owner necessarily. You know, do you have a governmental entity who owned the property 20 years ago? Or what sort of property is involved? Is it hunting property, a city lot? Those are important things to know about property and deciding if you have adverse possession. When? Are we talking 20 years of adverse possession? Was it occupied between 1930, 1950? What time period? Where? How much property is involved? What is the actual boundary line that's in dispute? And why? There was a recent case in Wilcox versus the state of Hines that told us it is important why you were possessing the property. Did you intend to possess it? Was it with the permission of the true owner? Did you think it was your property? And then very importantly, how? What were your acts of possession that constitute adverse possession? When I have all that information, I sit down and I think, does this equal adverse possession? I compare it to the case law. And then I start to think about possible defenses and different related doctrines maybe that could come into play, such as acquiescence or easements. Attorneys should know that the statute isn't going to answer their questions in most cases. You need to look at the entire body of law that has developed over time. The adverse possession statutes actually codify the common law. And so there are different elements even in the cases than ours are listed even in the statute. So the elements of adverse possession are continuous, exclusive, open and notorious, and hostile possession. Whereas there is no reference of most of those terms in the statutes themselves. Attorneys also need to know that you shouldn't just look at either the first case or even the last case. It's been a long and complex doctrine that has evolved over time. And a good place to start is probably the latest case, but there are plenty of cases from over 100 years ago that I still reference and that are still relevant good law that you will need to be aware of. Part of why I wrote my article is sometimes it's really hard to find a good summary of adverse possession law. A lot of the treatises will have it, but that's on a nationwide basis. And our state, along with a lot of other states, has developed the law in its own way. So I think the best way to sort of follow along and know what you should be looking at is to just go through the cases. You're going to have to do your case law research. Hopefully my article will give you a good starting point. But from there, you just have to get into the topic.
All right, so that was from the perspective of an attorney that specializes in adverse possession suits. So
bit more bizarre business story. We're going to talk about the head.
let's look at a couple of these cases in the news where adverse possession takes place, where it's dangerous, where some people think they know the law, but a little information can be a dangerous thing. Like in this example, we have, well, you can also look at the news recently, you know, where you got that, remember that illegal immigrant that was on the news that he was posting videos on social media telling people, yeah, come to America. You could just go sit in somebody's house and claim ownership of it and it'll be yours. He was kind of a little bit off on how that works. He became infamous for the wrong reasons. But take a look at criminals, how they use this.
Headlines about the young man moved into a $2.5 million mansion near Miami without paying a dime. We first told you about this story Friday morning, but we're now learning that this has become a national trend, and some of the people doing it are even connected to an anti-government group the FBI classifies as domestic terrorists.
Yeah, that's those sovereign citizens. If you ever watched Cops or Live PD on TV, you know those people that say, oh, I wasn't driving, I was traveling. I don't recognize your laws. I'm a sovereign citizen. I'm not a citizen of your country, your nation. I'm independent. So I'm just traveling. So I don't need to follow your laws. I don't need a license. And these people are usually crazy and out of their minds. But that's what the sovereign citizen movement is. And that's what they're talking about, the domestic terrorists. Here.
Boca Raton, one of the poshest zip codes in Florida, is abuzz this morning over what is happening inside this $2.5 million, 7,500 square foot waterside mansion. The bank foreclosed a couple of years ago, but now a 23-year-old named Andre Barbosa has simply moved in.
Nobody's happy. We all spent a lot of money to live on this too.
Barbosa is using an obscure legal concept on the books in every state called adverse possession, which says if you live in an empty home for a certain amount of time, it's yours. Adverse possession is being attempted all over America. Susan Weidman took over a series of homes in the Atlanta area.
I filed adverse possession back in February as Susan Whiteman at the DeKalb courthouse.
Okay.
So I'm not just, transient squatters here.
This $3.3 million house near Raleigh, complete with an elevator, got caught up in this whole mess when Sean Pendergraft claimed he owned the house. Out of town. Everything we're doing is lawful. There have always been squatters, but the housing crisis has put the phenomenon on steroids. Some of the people using adverse possession are connected to a sometimes violent anti-government movement known as sovereign citizens, who believe U.S. laws do not apply to them.
A police officer walks up to someone who is claiming a house now belongs to him without any basis at all, is handed a big sheaf of documents which are incomprehensible, and I think very often the officers ultimately feel that they're forced to go back to headquarters and try and figure out what's going on before they can actually toss someone in the slammer.
I met a young sovereign named Robert Peterson who moved into this foreclosed home in Idaho.
They're the enemy. They're the enemy of anybody who wants to live free.
One expert on sovereigns found evidence to suggest that Andre Barbosa, in that mansion in Boca Raton, is connected to a sovereign group called Divine Province, based on the language Barbosa used to justify moving into the mansion and the fact that his name is on the group's website. Before you get any ideas about trying to use adverse possession, consider that the sheriffs forced Robert Peterson out of this house, and remember Susan Weidman, arrested for racketeering, and Sean Pendergraft, also arrested for obtaining property by false pretense.
All the legal arguments he may make or the documents he may file will all end up leading to the same conclusion. And that is that he gets kicked out because he has no legal right to be there.
As for Andre Barbosa, he may be running out of time in that mansion in Boca. Bank of America has now filed a claim in court claiming it is the rightful owner of the home.
It's so crazy that they're arguing that the law's on their side.
They are, and they're kind of 1/3 right.
Fascinating story. All right.
It is kind of wacky, right? But the thing is, look, we get people all the time that they think they know the law because they heard of something, they read it online, or I saw a YouTube video that shows me how I could invest in real estate and become an owner with no money needed, no money down. I could just take over some vacant home and then squat in it and claim ownership. And in the meantime, until I get that ownership, I'll rent it out. Think about that for a second. You don't own a house. You broke into it. You changed the locks. And now you're renting it to someone else and collecting a rent? How does that not sound criminal to you? Hey, the younger generation, man, they're looking for, and just lazy people, they look for easy ways to get rich, if they use half of their mind power, some of these people can actually be intelligent. If they used half of their mind power to do good, they may actually come up with and be successful people, but then you also run into people, other folks like
Now a
these.
warning about the risks more and more people are taking to get a house for next to nothing. It's an obscure law some hope to cash in on, but often land in jail instead. Chris Trinkman joins us live in Polk County to explain more on this. Chris?
Well, the sheriff says some people never learn. This is the house in question. It's valued at $160,000. It's in foreclosure, and both deputies and residents here are baffled why a couple thought by breaking in, turning on the power, water, and cable, they would have the right to own the house without paying for it.
This sheriff, you probably see him on TV. This is in Polk County, Florida. He's the Polk County sheriff. This guy's a trip. I mean, first of all, I love him because, he tells it like it is. He encourages people to, protect their families, protect their own houses, believing in the Second Amendment. He's like, somebody breaks in their house, you shoot them. You use a, but this guy's a trip. When he starts talking about these people who have broken into this house, listen to this. This is nutty. This is batty.
with the homes being vacant, it just takes neighbors in the neighborhood having their eyes and ears open.
Danny Rodriguez says residents along Echo Lane noticed a locksmith changing the locks and moving trucks unloading furniture into this vacant house. As the Homeowners Association president, familiar with his neighbors, Rodriguez suspected a scam.
I knew a little bit about adverse possession just from doing some research at saying you need to be in the home for 7 years. And I knew they weren't here for 7 years.
Adverse possession is a Florida law from the 1800s that applies to unoccupied farmland. The property appraiser alerted sheriff's deputies about Sherry Fields and her husband after they filed for the obscure law. They were charged with burglary and grand theft. Meanwhile, Sherry Fields is a teacher at Fort Meade High School.
Come on, girl. You know, you got a college education. You should know better than that. But anyway, we gave her a field trip to the county jail.
Sheriff Brady Judd says more people are learning about adverse possession from websites online, mistakenly thinking they can use the law to take over an unoccupied house for free.
And hold on, this is so true. I came across a video on YouTube where there's these guys, they're teaching a class, they're teaching a course online on YouTube. They got all these videos. You know, they earn money by clickbait. Anybody that clicks on it and watches the video, YouTube, Google will pay them for generating traffic, and they sell ads during the video and all that. You know, so they make money just by publishing these videos too, but they also sell a course for people to learn more about it. And so basically they got all these videos on YouTube, on a YouTube channel, teaching people how they could invest in properties using adverse possession. Well, how are you investing in it if you're just taking it? You know, they're the ones that are talking about this, just taking over a property, changing the locks, and then in the meantime, till you get the ownership established, you rent it out. You know, most people don't ever establish that by breaking into a house that's empty, unoccupied, you know, it's maybe for sale or getting foreclosed on. You know, it's not going to be like that forever. You know, somebody's going to come by at some point, you know, and you're breaking the law. You've seen all these people getting arrested for this. You know, I report these videos every time I see them to YouTube, and I explain to them that this is illegal what they're doing, and they're encouraging people to break the law. And YouTube says it's not against our terms of service. Yeah, you know, that's so incredible. It blows my mind, you know. But you know, you give a little during the days of COVID, you talked about ivermectin or anything like that, or any doctor who had an opposing view of the approved narrative. You're in Facebook jail. You violated their terms of service. But you know, somebody here advocating the breaking of law, it's not against our terms of service. You know, blows my mind.
We all know if it's on the internet, it's got to be true. Well, what they didn't see on the internet was my Facebook page that says, "We will put you in jail."
You know, we work hard for our homes and what we have, and it's not fair for someone to just come in and take somebody's possession like that.
And the sheriff says the school teacher and her husband are going on another field trip, this time for a crash course on Florida law. They'll be in a courtroom tomorrow. We're live in Polk County. Chris Trankman, ABC Action News.
Yeah, it's the nuttiest thing.
Now a warning about
And here's another. Check this one out.
Caught in the act, how one woman stopped a group of squatters from moving into a vacant home she owns.
So some states have tenant protection laws. I think this particular one that they're showing as an example is California, where they give tenants the rights and screw the property owners, the ones who worked hard, slaved hard to save the money and buy a home and then be able to rent it out to people and earn some money by renting out their home, becoming landlords. It's their home. They pay taxes on it. But you get some of these states that they're tenant rights states. They give tenants the benefit of the doubt. New Jersey's one of them as well. New Jersey often follows California with a lot of the nonsense that they pass as laws. The thing is, though, that they're kind of to the extreme, because New York was the same way until they just changed it once people were getting murdered and you seen all the illegal immigrants just breaking into people's houses and using them as their own because New York passed a law against squatters being able to claim adverse possession because of all these extreme events that have been happening there. Well, check out this one. This is another one where people know you got some criminals, they know the law, and they're going to use it to their benefit. And this could happen anywhere. This could happen in anywhere, especially in states that are primarily tenant rights states. They prioritize tenant rights. New Jersey is the same way. We prioritize the tenant right over the owner for residential property. Commercial property, it's the other way around. The property owner has more rights than the tenant because the tenant's a business owner, so they should know better. So that's the way they look at it.
Good evening, I'm Jackie Parks.
And I'm Todd Carley, 23 ABC's Mark Christian is live tonight from a home in Oildale where those squatters were trying to take up residence. Mark?
Well, guys, if you think if someone is living in a home illegally, it'd be a simple case to get them out. Well, squatters move under the radar to try to move in very fast, and in some cases even changing the lock so they can move in before the owner finds out.
I felt like about 20 people at my property trying to move in as fast as they could.
After her previous tenant moved out, the home had only been vacant for 10 days.
Unfortunately, some of these squatters have gotten pretty sophisticated.
Rena Chanty was getting her home ready to put it up for rent when a neighbor called to tell her someone was trying to move in. The squatters were moving in a refrigerator, a washer and dryer.
Basically everything a house needs. They were even putting up their decoration pieces, and they had changed the locks.
When deputies arrived, the squatters were still in the process of moving in. Though not commenting on this specific case, Ray Pruitt with the Sheriff's Department says the squatters can take refuge under the California tenant law, and they've even been known to falsify rental agreements.
Once they're in that property, in some cases, it's very hard to get them out of that property without legally evicting them.
In cases like this, law enforcement's hands are tied because if the squatter presents what appears to be a legal agreement, it comes down to he said, she said.
Sometimes we can't determine if the squatter's in the home legally or not.
They know the system and they know how to play the system.
Fortunately for Chandy, the squatters did not get that far and could not provide any documents to law enforcement.
At that moment, the cops told me it was my word against their word, and I had to prove that I owned the property, which I had the paperwork on me.
So right now, Chandy is checking her house daily until she can officially get it rented. In the meantime, she's asking her neighbors to keep a watchful eye until that place gets rented. Back to you, Jackie.
Imagine having to check on your house every day, every single day, to hope somebody's not trying to move in really quick and claim that they have rights to be there. Now, here's an interesting one. And a real estate agent's involved in this too, because a real estate agent is the neighbor. And I think she was also got a listing on this property for sale. And because she wasn't able to sell it, she got all bent out of shape, and now she's playing, she's actually causing more of a problem than anything here. Check this out.
This is a wild story. In the news from Orlando, there are big questions tonight about what is going to happen to this house in Wayview Park now that a boundary dispute has reached a whole new level. Check out this new fence. It splits a pool in two. Channel 9 Shannon Butler is live there in downtown Orlando. It's just south of downtown. And Shannon, this fence has neighbors scratching their heads and wondering what will happen next year.
Yeah, if you walk down the street here in Wayview Park, it looks normal, right? There's a house on this lot. There's no house on this lot. But if you look behind the bushes here, you can see the guy without a house has put a fence on the guy with a house, making it clear where the property lines stand. Now everybody is asking, what's this guy do now? This home along Harding Street sat vacant for years, all because of a boundary dispute. The MLS listing says, quote, the pool and the garage are partially on the adjacent parcel and not included in this sale.
Stop right there. Would you take a listing like this?
No. Nope.
This is a freaking headache. I would say you need to clear this problem up before you put the property on the market for sale. You're going to have a tough time selling it like this, just passing your problem on to somebody else. You need to get this problem resolved first.
Sale, huh? It's such a mess that realtors don't even want to touch it. This realtor posting about it saying, quote, My job as a realtor is to help people buy and sell properties. Sometimes my job is to help people not to buy. So the house was just sold at an auction, and now what was a dispute has been taken one step further. The owner of this lot seemed to have put up a fence right through the pool of the other guy's lot, splitting the garage and that pool in half.
That's where we stand now. We have a brand new owner of this house, and this is how they choose to make their statement to the new owner.
She's a neighbor and realtor. I think that was her listing. She wasn't able to sell it. And now she's all bent out of shape because this guy who does not have the house on his lot, he's saying, listen, the city allowed this guy to build his house over the property line. And so I have to defend my property. This is my property. It goes up to here. They built on my property. He's not doing anything wrong. She's acting like he's a jerk off doing something wrong. It's his property. He's defending it. Boo hoo! You didn't get your sale. You know. But he's saying to the city that, listen, if you give me a permit to be able to build a house on this lot, which is now smaller than what you normally allow somebody to build a house on, I'll take the fence off and it'll be fine if you give me the permit to do that. What do we call that permit that allows you to do something, to build something where you're not normally allowed to build? Or to, I don't want to give it away by saying a word. It's called a variance. The permit is called a variance. It allows you to vary from the current zoning requirements to be able to build something that's normally not allowed according to current zoning laws. So if you don't have a large enough lot to build a house on, you could apply for a variance because of a hardship or because of an issue. And the city could allow this. However, you got to then send out a letter to all the neighbors that live within 300 feet and make sure none of them have an issue with it. Well, this realtor that was trying to sell this house that got screwed out of the sale because he put up a fence protecting his property, she's all bent out of shape now, and she's given reasons why, well, I don't know if we should do that because now look what he caused here. Yeah, he was defending his property, lady.
Lisa Sconiers is a realtor and has lived across from the two properties for years. The history is long and sordid, but the easiest way to explain it is that both lots were owned by the same person, a house on each. He then sold them to the new owner, who then cleared the lots to build one big house. But that owner went into foreclosure and the lots were sold to two different people. So now this house is over the property line of the other lot. In the end, Sconier says this could have all been avoided. The city of Orlando didn't permit this the right way. What they should have made these people do is they should have made them replat the property into two separate properties. They never did that. Now, we have reached out to both sides and the city. We're still waiting to hear back. Now, when it comes to this property here, this property owner is trying to get a petition. He's gone around to the neighbors, asking the neighbors to give him an exception to back it up because this lot isn't big enough for a house, to allow a house to be built there. Now the neighbors are saying, I don't know if I can back you on that because you asked us to do that before you did this, and this problem still isn't solved. We're live in Orlando.
Of course he did this first. He has to try to protect the property. And then he's trying to get that variance permit. And if he gets a variance approved, then this problem can be solved. But if it can't be approved, he needs to get his property back, and this house needs to, or at least this part of the house needs to be torn down so that he can reclaim it, so that he'll have a large enough lot to have a house on. Isn't that interesting the way that it's reported?
Not much, yeah.
All right, so a party wall. What is a party wall? Party wall is a common wall that separates two structures, like with townhouses and duplexes, where you got two units side by side connecting each other in a two-family duplex. They're side by side, or townhouse, which is multi-level attached housing, condominiums and such. They share a common wall that separates the two living units. Okay, that's known as a party wall. In the past, party walls were built to separate two people's properties, the large property overall. Now it's more common term used, we use now just fences to separate our properties, right? Our boundaries. But party walls, now we refer to them more as those common walls in this construction that separates two units. So a party wall is a wall of a building that straddles the boundary lines between two owners' lots. That's what a party wall is. Okay? This is page 111. And license, you should already have this highlighted, right? And you made this note down there. License is permission to enter the land of another for a specific purpose. And license, that permission may be revoked at any time. Here's an example of a license. Hey, neighbor. Feel free to come over to my house. You can use the pool anytime you like, even if I'm not at home. I just granted you a license to come over to my house and hop in the pool, take a dip if you want. Now we get into an argument. I don't want you on my damn property anymore. I just revoked your license, and it's as simple as that. Doesn't need to be in writing. Not like the easements. Okay? No rocket science yet. Everybody's understanding everything I've been explaining up to today, right? Or all these days up to today, right? There's no science involved with any of this stuff. It's just a lot of stuff to remember and learn, right?
Yep.
Okay, so here we go. Party wall, license, easement, and encroachments all on one slide here for you. Encroachments we didn't quite go over yet, but here's the definition. It's anything that crosses over the property line as when a part of a building, fence, driveway, or any other installation illegally extends beyond the land of its owner onto the neighbor's property. Now, I got this from a student one time, gave me this gem. Here's a way of remembering it. The word encroachment has the word roach in it, and much like a roach, it's something you don't want on your property. That was pretty clever. All right, so if you guys want a snap picture of this slide, because it's got these three definitions there, or four. And we're almost done with this chapter here. So how do you create an easement? Well, here's a screenshot from the book, and that's just me typing it up a little bit, explaining. Express grant of the permission by the property owner. By a deed conveying the property and creating the easement over the sold land. Granting the new owner an easement over the grantor's remaining land. By long-time usage. Well, what kind of easement is created by using the property? That would be the easement by prescription. But it needs to be perfected in a court of law. By necessity. That's for the purpose of ingress and egress of landlocked properties. Or an easement in gross, that's a public utility or municipal easement. They could ask the owner for permission or just take the land if it's needed for a greater public good. You guys know that the first 6 feet of your property, your town and the utilities have easement rights for that?
Yes.
If you ever got a survey, you could even see that where they put the survey stakes in. They won't put it all the way up to the curb where your property line is. They'll have it set 6 feet back, even though your property does go all the way up to the curb. But they do have an easement right. That's interesting. All right, the ways to terminate an easement is when the purpose for the easement no longer exists, but that only applies to the easement in gross, when it's no longer needed. When the owner of the dominant or servient tenement becomes the owner of the other, because you don't need permission, you don't need an easement to cross over your own land. So if you buy your neighbor's property where there was the easement goes away. The dominant estate can release the easement right to the owner of the servient or by abandonment. However, good luck in trying to to terminate an easement this way. You have to prove what the intent is and going on in somebody's mind. you know, and courts have ruled that simple non-use of a property does not constitute abandonment of that property. You would have to prove that person's intent was to abandon their easement right. Okay, so here's where you would highlight the thing on encroachments. This is on page 112. And then also on 112 is deed restrictions, also known as restrictive covenants. The covenant is a legal promise. This is a restrictive legal promise that you agree to abide by when you take ownership of a property. What kind of estate in land has based on a restriction? It's ownership forever based on a restriction. Well, I wrote over here, fee determinable, defeasible fee, or conditional fee, which we went over on page 104, but I just wrote it over here because they're talking about deed restrictions. Those restrictions are called restrictive covenants, and it's found in what kind of estate and land? Fee determinable, defeasible, or conditional fee estate. These are restrictive clauses added to the deed when the property is conveyed that established by the seller to restrict the future owner's use of the property in some way. You see it more often in commercial real estate, but it can also be found in residential sometimes. You know, developers often do this. They say you can't, the minimum lot size that cannot be subdivided any further, or the minimum lot size can't be less than a certain amount because they're trying to preserve the community. Or they could put a deed restriction that you can't paint your front door orange, you know. They want to keep some kind of uniformity in the community. Because uniformity maintains values better. Restrictions are placed in deeds by private parties, not by governments. So who could place a restriction in a deed? The owners. The government does not place restriction in deeds. They got their own powers that could restrict how you could use your property. Zoning laws, rules and regulations, stuff like that. Only a private party can place restrictions in deeds. These are restrictive clauses added when the property is conveyed. They're established by the seller to restrict the future owner's use of the property, and they run with the land from one owner to the next. And the type of estate based on a restriction is a fee determinable, defeasible, or conditional fee estate, which we went over on page 104 and 112. Let me know if you need more time to finish writing that in, or if you have it already.
Got it.
So in this chapter, we pretty much finished it. In this chapter, there's two key terms to review in this chapter. And next to, so does everybody have this, or is anybody still writing?
Got it.
So that's the end of this slideshow for this chapter 6. So we need to do the key terms to review now. So key terms 1, next to letter A, we're first going to make some changes here. Next to letter A, it says ownership lasts indefinitely. Cross out the word indefinitely and write forever or a lifetime. Pencil it in there small. Forever or a lifetime. Next to letter A for key terms to review 1. You crossed out indefinitely and wrote forever or a lifetime. Next to letter E, you're not crossing anything out. You're just writing at the end of that line where it says ownership as long as. You're going to write based on a restriction. That's what that as long as means, as long as you don't violate the restriction. So it's based on a restriction. You're writing after that, as long as. And then next to letter F, as in Frank, it says amount of ownership. I crossed out the word of ownership and I wrote, or kind of interest in real property. So it would read amount or kind of interest in real property. Or kind of interest in real property. And that's next to letter F. So it should read amount or kind of interest in real property. Let me know when you're done writing there. I know it's small and it takes a little more time to write that.
Got it.
Okay. So go to key terms 2, and we're going to do a couple corrections there as well. Next, the letter D, as in David. It says, notice that a lien may be filed. Wait, does it say? Yeah, notice that a lien may be filed. Cross out the word lien and write, notice that a lien may be filed. You know what? You don't have to cross out anything. Just at the end of the line there, put / legal action. So it says, notice that a lien may be filed / legal action.
Could you repeat that?
Yeah, next to letter D, key terms 2, letter D. At the end of the line, put a / and write legal action.
Thank you.
You're welcome. And then go to letter J. And cross out the word will. It says third party who will gain eventual ownership. Cross out the word will and write may. And then next to letter L, this is the last modification. Next to the letter L, before the line, I guess the only way to write it is probably above the first letter of the first word there that says future interest of an owner. Write possible, the word possible, because it should read possible future interest of an owner. And once we're done with that, we can go to key terms to review 1 and get started. Are you ready?
Got
So let's do it. Ownership lasting forever or a lifetime.
Is simple.
freehold estate.
Freehold estate, you're free to hold that property forever or a lifetime. So 16 is A. Permanent right to use another's land. Permanent
easement.
Easement, 6 is B. See, an easement is a right, and they're not giving you enough information to tell what kind of easement it is. So it's simply an easement. Husband's right in the wife's property.
Courtesy.
Courtesy, because men are courteous to women, or should be, right? So courtesy. 3 is C. That's the way you remember that one. 3 is C. A right that runs with the land.
The easement of pertinent.
Yes, 7 is D, because they specifically say that. So easement appurtenant is a right that runs with the land. 7 is D. Ownership as long as based on a restriction. So what kind of ownership is based on a restriction? It's
Be
long,
determinable.
ownership based on restriction. 14 is E, the fee determinable estate. Amount or kind of interest in real property.
Estate and land.
Described as an estate in land. That would be correct. 13 is F. A right used for utility lines on another's land.
That's easement and gross.
Yeah, that's a utility easement, the easement in gross. 10 is G. A right of access to a landlocked parcel.
Easement by necessity.
Yeah, because it's necessary to cross over someone else's land to get to yours. 8 is H. A wife's right in the husband's property.
Dower.
Dower, because dower begins with a doe, and a doe is a deer, female deer, right? It's silly, you know. I got some silly things that I bring up. These are silly ways to remember, but if they help you, hey, there's no wrong way to learn or to remember. You know, if you got a better way to remember things, go with it, you know? So 5 is I. A right sometimes acquired through usage. What kind of rights are acquired through using?
Easement by prescription.
Correct. The easement by prescription. You have to use somebody's property for a period of time as prescribed by state law. So 9 is J. Transfer by sale or gift.
Convey.
2 is C. 2 is K. Sorry. Transfer by sale or gift. 2 is K. Convey. A property that benefits from an easement.
The dominant estate.
Yes. 4 is L, the dominant estate. A most complete form of ownership of land possible. Unrestricted ownership forever. Yes, yes, I heard you guys saying it. Sorry, I'm talking over you there. Fee simple. 15 is M, as in Mary. Any easement, encroachment, etc.
An encumbrance.
They are all encumbrances on the property. 12 is N, as in Nancy. Placed against real estate by a worker who has not been paid.
Construction lien.
And what are construction liens also known as? Does anybody know? It's a mechanics lien.
Mechanics.
Lien, yeah. So 1 is O. Construction lien, also known as mechanics lien. If you wanted to write that there next to number, construction lien, mechanics lien.
Yeah.
Building intruding on another's land.
Encroachment.
They're encroaching onto your territory. Correct. 11 is P. All right. All right. Everybody excited about all the real estate stuff you're learning?
Oh, yeah.
All right. Key terms 2. Yeah, I know it's boring stuff, guys. I'm just trying to make it as possible, and it's not that easy. All right. All right. Structure owned by 2 adjoining landowners. What do we call that?
Party wall.
9 is A. 9 is A. Party wall. Claim against all property somebody owns.
General lien.
A general lien. Yeah, they can file that against all your property that you own, including any personal property. That would be a general lien. So 1 is B. A claim against one parcel of real estate.
A specific lien.
Specific lien, yes, a specific lien only affects one specific parcel of land, correct. 14 was C. And notice that a legal action may be filed, or lien or legal action may be filed.
Lis pendens.
Lis pendens.
A lis pendens, it's a public notice of possible future legal action. So that's why I had you write legal action there. So 7 was D. Lender's claim against real estate.
Mortgage lien.
Mortgage lien.
Mortgage lien. 8 is E as in Edward. Temporary permission.
A license.
A license. 4 is F. A right to use and possess for a limited time.
A leasehold estate.
Yeah, leasehold estate. You know, you're leasing somebody's property. You're not free to own occupy it forever. It's for a limited period of time, as defined in the lease itself. So 3 is G. Property taxes are 1.
Involuntary lien.
Yeah, who wants to pay those things, you know? You still got to pay them, though. They're imposed on you. They're not with your consent. 2 is H. The order in which liens are paid.
Priority.
Yeah, they get established by their priority. And what establishes the priority of those liens? Dare I ask?
Well, taxes are always the priority, but based on who's recorded first.
Correct. It goes by the order on which the date of recording in the public records. That is correct. So 10 is I, priority, and that priority is established by the date of recording in the public records, with the exception of taxes and the contractor's lien, the mechanic's lien, because that's retroactive back to the date the materials were delivered or when the work began, whichever occurred first.
Right.
So third party who may gain eventual ownership.
Remainder man.
Remainder man.
That's a remainder man. 11 is J. The tract over which an easement runs.
The servient estate.
We refer to that as the servient estate. The tract over which the easement runs is a servient estate. You have a dominant estate and a servient estate. The dominant's the one that benefits from the easement. The servient is the one who's serving their property up on a platter for others to walk all over. So 13 is K. Possible future interest of an owner.
The reversionary interest.
12 is L, the reversionary interest. There's the possibility that that ownership can revert back to a previous owner. Correct. 11 is J. Oh, wait. Reversionary interest. That was 12. 12 is L. Adding successive periods of usage.
That's tacking.
You tack on one person's time to that of another. So 15 is M as in Mary. That's tacking. Complete ownership until someone's death.
Life estate.
It's a life estate. 6 is N. And what do we call a life estate based on someone else's life?
Yeah.
What do we call that?
I gotta go back.
It sounds French.
Autre.
Something over.
Pour autre vie. A life pour autre vie. For the life.
Autre vie.
Correct. 6 is N as in Nancy. Financial claim against real estate.
Lien.
Lien.
Correct. 5 is O. And a mortgage or equity loan, for example.
And a voluntary lien.
Yeah, you went out of your way to get those ones. 16 is P. And that concludes chapter 6.